Assalamualaikum warahmatullahi wabarakatuh. A very good morning, ladies and gentlemen, all distinguished delegates of INCLAR 2024. On behalf of the committee, I would like to welcome everyone to the 5th International Conference on Law Reform 2024 conducted by Faculty of Law, University of Muhammadiyah, Malang. Ladies and gentlemen, it's an honor and privilege to me. My name is Rahmania Santoso to be the master of ceremony for this loving morning. And first of all, please allow me to express our gratitude and warm welcome to the Honorable Professor Dr. Sigit Rianto as our keynote speaker, Vice Rector of Research, Community Service and Partnership, University of Muhammadiyah Malang, Mr. Salis Yuniardi, PhD, Dean of Faculty of Law, Professor Dr. Tongat. I also would like to welcome all of our speakers here. Professor Hilary Tegnan from Center for Legal and Court Technology, William and Mary Law School, Williamsburg, VA, USA. Mr. Hasnan Bakhtiar from Deakin University, Australia. Dr. Teng Junaidi Gunawan from Universitas 17 Agustus, Surabaya. Associate Professor Fokke Fernhout from Maastricht University, the Netherlands, Mr. Najih, PhD, the Chief of Ombudsman of the Republic of Indonesia, and also Professor Jadi Zaidi Hasim from Universitas Kebangsaan Malaysia, and also all of the representatives of our co-hosts. And I would like to extend our deepest gratitude to all the delegates of the 5th INCLAR 2024. Ladies and gentlemen, the first agenda is reciting Holy Quran. Ms. Ita Purnamasari, time is yours.
Assalamualaikum warahmatullahi wabarakatuh. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. يا أيها الذين آمنوا إذا قيل لكم تفسحوا في المجالس إذا قيل لكم تفسحوا في المجالس فافسحوا يفسح الله لكم وإذا قيل انشزوا فانشزوا يرفع الله الذين آمنوا منكم والذين والله بما تعملون خبير. والله بما تعملون خبير. صدق الله العظيم. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Miss Ita Purnamasari. Ladies and gentlemen, we would like to ask you to stand up and sing Indonesia National Anthem and Muhammadiyah Anthem. Indonesia Raya.
Dua mengikat warna yang hijau berseri membuatku rela hati. Ya Allah, Tuhan Rabbiku, Muhammad junjunganku, Al-Islam agamaku, Muhammadiyah gerakanku. Di timur fajar cerah kemenapan mengusir kabut.
Please be seated. Ladies and gentlemen, now I would like to invite Mr. Muhammad Salis Yuniardi, PhD, Vice Rector of Research, Community Service and Partnership, to come to the stage, deliver the speech, and open the conference. Mr. Salis, time is yours.
Speaker, Professor Dr. Sigit Ruyanto, yeah, from University of Gajah Mada Malang, University Gajah Mada Yogyakarta, yeah, and then also Professor Tongat as the Dean of Law Faculty of University of Muhammadiyah Malang, and also for other speakers, I will read one by one. Associate Professor Foke J. Fernshut. Yeah, please apologize if my pronunciation is not correct. Yeah, from Maastricht University, Netherlands. Yeah, you look so handsome with the batik today. Yeah, hopefully you enjoy the batik. Yeah, and then also Professor Hilary Taknans from William and Mary Law School, United States of America. I think he will attend online. Yeah, and then also Professor Dr. Jadi Zaidi Hussein, is it correct or not? Hashim, yeah. Hashim, from University Kebangsaan Malaysia, yeah. And then also Dr. Teng Junaidi from University 17 Agustus Surabaya, and also my younger brother Hasnan Bahtiar, yeah, from Deakin University. I think he will attend through Zoom as well, is correct? Yeah. And in my remarks, yeah, first of all, I would like to say welcome to UMM, and representing our rector, he sent the warmest regard for all participants, and he has apologized because he is right now is in Brazil attending the G20 meetings, yeah, in Brazil, accompanying Professor Muhajir Effendi as the Menteri Coordinator for Human and Social. Yeah. And then in terms of this conference, I think the topic is very, very deep. Yeah. Redefining humanity values, the basic of legal rationing, yeah, as the challenge in the disruption era. Yeah. Very, very deep, very, very philosophic, and I have no words, yeah, what it's about, yeah. But in my background, yeah, I am from psychology. I agree with that we need to redefine humanity values, yeah, including starting from redefining the definition of humanity as well as moment, yeah. Because in this disruption era, for example, we live so engaged with technology, we can't live without technology. And so, for example, it is common now, if there is a crime or there is a car accident, we get confused. What should we do first? Helping the survivor, the victim, stopping the crime, or should we record and share it through our social media first? Yeah, we get confused, yeah, particularly for young people. Yeah, and the other example is we now live borderlessly. The world is moving so fast simultaneously. Yeah, and it seems that we now live in single culture. Yeah, in the social background, we know a well-known sociologist, Hofstede. Yeah, he divide and he classified culture based on culture dimensions. Yeah, For example, Indonesia is very high in the poverty and also in the collectivism, yeah. And Indonesia is tend to be feminist community culture rather than masculine or competitive culture. Slightly different with Malaysia, which is Malaysia is higher in poverty, yeah, but less in the collectivism compared to Indonesia, yeah. But we need to ask this culture dimension at this moment because most generation nowadays generation or Gen Z generation is live in internet, and in internet there is no such day of culture dimension because people live with border, yeah, without any norms, without any hierarchy, yeah. So there is no any in the reality I have to respect Prof Tongat, for example, because he is older than me, yeah, he is also professor, yeah. But what happened in the internet, yeah. And also few months ago I met with a friend from United States and we talk about the meaning of democracy. What we mean is democracy in the internet, yeah. Which one is the truth? The law or the voice of netizen, yeah. For example, in Indonesia, in the last months, I think in the last few months, it's quite viral with Vina from Cirebon, yeah, Vina from Cirebon, yeah, and it's still unclear about the law, yeah, behind the crime case, yeah, because not only the case is already around 8 years ago and all the evidence has been probably broken, but also the noise of the netizen is very very loud, yeah. One is pro with Egi, yeah, the other is contra with Egi, yeah, the other supporting Ibtu Rudiana, the another is supporting police, the another is against the police. So the voice of netizen is very loud, yeah. And then it seems that police and also from law academician, yeah, get confused, yeah, which one must be followed, yeah. So this is indication that what is the word has changed, yeah. Where simulacrum is accepted as the real one, as the correct one rather than the reality itself. If we look at back at the Foucault, yeah, Foucault theory about simulacrum, yeah. While we understand actually, yeah, that simulacrum is not the reality. It is only an image of the reality. But people who live in internet can accept the simulacrum as more truth, yeah, the truth one rather than the reality. This is also the example of the change of our nowadays world, including how the young people live now, yeah. If we talk with our student nowadays, yeah, sometimes the lecturer in UMM I know talking about young student, yeah. They send message to the lecturer, yeah. Sir, I need signature. Where can I meet you? While for us, yeah, who the age is already 40 years more, yeah, it's very impolite. But among young people, it's correct because they used to live in internet where there is no border. If we get angry, for example, Professor Tongat get angry, he will get stroke soon, yeah, because notice he will have to face a kind of this such student, yeah. No, sir, please apologize. May I meet you? Is that okay? Or you don't mind if I meet you? No, sir, I need your sign today. Where can I meet you? Yeah. Sometimes we get confused. This is student or debt collector. Yeah. I think that's all. And based on this reality, I think it's very very important for law department, yeah, for people in the law background to discuss about the rationale in the legal, yeah, the rationale in the recall for this disruption era, yeah, where technology very have big influence, yeah, while young people, yeah, who will lead this nation, yeah, in the next 20 years, yeah, possibly is has different character with other people like us now, yeah. Okay, that's all. Thank you very much for the your participants, and enjoy the events, and Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Mr. Salis. Please remain on stage. I would like to invite the Dean of Law Faculty of UMM to come to the stage to accompany Mr. Salis to press the screen as the symbol of to open this conference. Please come to the stage. Okay, please allow me to comment you. Please press the screen in 3, 2, 1, and go. Ceremony, thank you, Prof. Tongat and also Mr. Salis. Could you please remain on stage? We invite Professor Jadi Zaidi from Universitas Kebangsaan Malaysia to come to the stage. There are some souvenirs from UKM for Mr. Salis and also Prof. Tongat. Will be handed over to Mr. Salis as the vice rector for UMM. And the second souvenir is for of Muhammadiyah Malang. Ladies and gentlemen, may we continue to the main event. This is the first session of the presentation, and the presentation will be delivered by our keynote speaker, Professor Dr. Sigit Rianto, SHLLM. So, Prof. Sigit, time is yours.
Okay, thank you. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Peace be upon you. Good morning, everyone. And Honorary Vice Rector, Dr. Muhammad Salis Juniardi, Honorary Dean Professor Dr. Tongat from Universitas Muhammadiyah Malang, and also my colleagues, Professor Foke Verenhout from Maastricht University, Professor Saidi Hasim from National University of Malaysia or Universitas Kebangsaan Malaysia, Dr. Najib from Indonesian Ombudsman Institution, and also other speaker which may join us virtually from other place. And of course, my colleagues, all of the participants, ladies and gentlemen, and also distinguished guests for this international conference on law reform, organized by the Faculty of Law, Universitas Muhammadiyah Malang today. Ladies and gentlemen, it is a great honor for me to be invited by Honorary Dean Professor Tongat to join this very important seminar, in which it is the 5th seminar on international conference law and reform. And also I am very fortunate to join with you as the first speaker in this morning, and of course there will be some also very distinguished speaker in this conference. Ladies and gentlemen, distinguished participants, to be honest, I have mixed feeling when receiving invitation from Universitas Muhammadiyah Malang and invited to deliver a very hot issue today concerning the humanity and also in relation with the legal reform and as well as in the disruption era. Why? If we discuss and debating humanity, actually all of us believe these values, the concern, the tradition, the content, and also the importance of this humanity for our life and our civilization. However, if we look into the reality, both individually, collectively, nationally, and globally, we should take a very important note on that, because there is what we call it could be hypocrisy or even an absurdity concerning the implementation of the humanity values and tradition among individuals, among the policymakers, both nationally and globally. So, in this very brief but important opportunity, I should modify my presentation as pointed out by the organizing committee to change slightly with like a modification about the rethinking of rethinking of humanity in the disruption era. So, in such a context, I would like to invite you to highlight this very crucial point concerning the humanity in our contemporary era. First of all, how we see the humanity from the point of view, ontological and also historical. We have understood what about humanity, but how we look into the ontological aspect and also historical background, very important to us to rethinking about that. And then how the humanity and law could be cross-fertilization relationship. Law could be strengthened by humanity, and humanity could be guarded by the legal institution, legal norm, and also legal enforcement. And also, how we look into the contemporary context, especially if we start from past century in the 20th and the present century, in the 21st century, in which we could identify that actually humanity could be put in the context of socio-political and also legal movement. And of course, humanity in the contemporary context, part of the global agenda, at least if we could scrutinize many international documents, many international agenda accepted and recognized by the international community, by the leader of the international institution and head of state around the world. And then of course, I should look or invite you how paying attention concerning the humanity with a very critical point of view. Why? Because as I have mentioned earlier, I have mixed feeling. On the one hand, it is very important issue for our civilization, but at the same time, we have to look into the reality that there is paradox. Could be hypocrisy, could be absurdity concerning the humanity in the implementation. And then how the humanity in the global context, especially if we put into the context of globalization and liberalization era in which everything has been changed, including what we could discuss later in the next discussion. And then the last one, as identifying that most of the participants is professor and also lecturer in the legal school, in the law school, on the legal institution, then I would like to invite you also paying the attention how we could mainstreaming humanity in our legal education. Because as professor, as teacher, as lecturer, one of the most important obligations for us is how to preparing next generation of lawyer, in which we could point it out how the humanity in the legal education, because it is a very important not only for the legal education itself, but also when our children entering the society, entering the institution, entering the corporation, or even entering the global competition. They are student now, but they would be leader tomorrow. Because they are young generation which we could nurturing and also educating and also guiding them to be a right person with right idea and with right choice and with right contribution in the society and in the civilization. So, first of all, concerning the ontological background, I should honestly quoted Mahatma Gandhi concerning the humanity, in which he highlighted that humanity in very one simple sentence, that the greatness of humanity is not in being human, but in being human. It is a very important message from Mahatma Gandhi to all of us. How we could thinking, behave, and treating other as likewise human. But it could also, if we look into the formal agenda and the word, then usually people refer to, for example, the Declaration of St. Petersburg in 1868. In which it is the first time that humanity inserted in the legal norm, legal standard, and in the international institution. Because at that time, there was war. But then, people also concerned how to humanize the war. So that there is a formal international declaration accepted 2 centuries ago. And then, if we look into the 20th century, after the Second World War, we find out that humanity also the important and also crucial idea behind the ending of the Second World War. International community establishing military tribunal, for example, in Nuremberg in 1945 to 1949, and also continue with ICTY, ICTR, and now we have an International Criminal Court. And in many decisions delivered by this legal institution pointed out how the humanity is a very important idea, not only from the philosophical but also from the legal perspective, how the international community would like to save the society in the future. Next. Okay, so for us who are working in the law school, working in the university in which we teach our students everything, and then we could find out that from the legal development, from the legal education, humanity is also, as I have mentioned, cross-fertilized with the development of the legal education that, and also legal science development in the contemporary era. If we could identify, for example, how many subjects of laws that actually inspire and also establishing the humanity, like what you mentioned, the natural resources law, humanitarian law, health law, and etc. Even in the criminal law and in anti-corruption law, you find out that humanity idea is a very basic but important idea and philosophical point that should be maintained, but also inspiring the legal norm, legal institution, and legal implementation. So there is a very close relationship, even dialogue and cross-fertilization between humanity and law, both academically and also practically. We recognize this idea not only in the classroom, but also in the society, not only nationally, but globally. When we, 4 or 5 years ago, have to deal with COVID-19, for example, the basic principle that guiding and also driving international society or global society is about humanity. How we maintain, we keep, we guard our society with humanity as erga omnes obligation. And now I think this important point also developed in many areas. Next. Could you move next? Okay, now, as I have mentioned that humanity could be put in the context of centurial in 21st and also in the 20th century. As I have mentioned, of course, with declaration of St. Petersburg and then Nuremberg military tribunal, etc. In the 20th century, after the Second World War, there is idea of universalizing the humanity in the form legal document, in the form of international instrument, likewise Universal Declaration of Human Rights, in which it is a codification and recognize that mind and standard setting in the last century. How the law, how the legal institution, how the political agenda should be guided and inspired by the humanity. And in the later development, we find out that humanity also, in form of the human rights standard, then accepted or even used as legal and moral justification for the criticism of status quo and also struggle against the foreign occupation, discrimination, and colonialism. So we find out that the decolonization process, the struggle against authoritarian regime, guided and inspired by the human rights, which the values coming from the humanity. And even in the 21st century, then there is a multi-level governance framed as the, for example, enforcement of international law, or even humanitarian intervention, responsibility to protect, and etc. So we find out so many institutions in this international area, both legally and politically, accepted by the international organization and also supported by state around the world. So next. Okay, in the later development that humanity also becoming global agenda in many document and also agenda that accepted by the international committee through international organization and also declaration and also international agreement and international standard around the world. We find out, for example, even in the education, starting from 20 years or 15 years ago, people of all of the education institutions should promoting sustainable development agenda, in which if we look into this agenda, as actually all of this agenda, poverty, health, human rights, conflict, education, and etc., guided by the values, tradition, concern, and belief in humanity. And it is part of the global agenda in many document and also many agreements accepted by the international community and also state around the world. Of course, there is a gap concerning how the implementation of the agenda. So, it is our homework how to filling the gap and implementing consistently concerning the agenda. We call it a sustainable development goal. So, including into education and also in other areas. Next. So, this is my critical point concerning humanity. As I have mentioned, normatively we believe that humanity is very important. But in reality, as I have mentioned, there is a hypocrisy and there is a absurdity. Look in the international, internal policymaker, for example. I would recommend that there are two books. It is very important in relation with how the betrayal of humanity by the state and by the government to their people. If you read, for example, the book written by two writers, first of all about why nation fail, and then the second was about the political order and political detail. What makes a nation successful is not because national resources, not because culture, not because climate, not because geographical position, but how the political and economic institution established with inclusive paradigm. Conversely, many nations with rich national resources, likewise our country, Indonesia, however, the policymaker designing the policy, setting the agenda, even making the law, legislation and regulation with an extractive paradigm. So what happened is that many nations fail, but another nation successful because with inclusive approach, while for the fifth nation, they use extractive approach in many areas. Many times I have criticized omnibus law in Indonesia, for example. And it is a very blatant example about how the extractive approach implemented by the policymaker. Thinking about the extraction and forgetting about the inclusiveness. And the result would be very dangerous for us, but also for the next generation. So that why I remind all of us, including myself, how to preparing the next generation as our student. Next, in another context, how the betrayal and hypocrisy of humanity, for example. We look into the international context, for example. I would like to start with a close example for us. We have United Nations, we have Universal Declaration of Human Rights, we have so many international standards after the Second World War. We have the decolonization process and etc. But remember, when Indonesia declaring proclamation in 17 August 1945, what happened is the government of the Kingdom of Netherlands conducting what has been called restore law and order. As I have mentioned, we have Universal Declaration, we have right of self-determination, we have decolonization, and we have United Nations. But at the same time, a new established state should deal with the very difficult situation due to the betrayal of the values, constant tradition of humanity. We actually inserted by the state who are initiating the colonization process. Another example in that, for example, if we look into the promotion of democracy from the West, democracy, right, if the elected is in favor of the West government. But if the elected is not in favor of the West government, especially in the US and the European, you could mention how many CIA conducting operation to topple down the government in many countries. And then another area in the recent contact, Palestine and Israel, how we could a very blatant hypocrisy and betrayal of humanity. In the operation conducted by the United Nations force, for example, in Iraq, in Libya, in the name of international law and order. But at the same time, it's actually international is only a footnote. And it is conducted by the global community, international organization supported by the big power, which initially struggle and also teach another nation about humanity. Yeah. And then next, could you move next? Okay. Now in the context of globalization, we have to find out that the situation is totally different about the law. How the law changing the subject, changing the substance of the law, and changing the nature of regulation, and also the role of law as well. So that we find out if we thinking about humanity in the context of legal regulation, in the context of legal implementation, in the context of legal institution, then whose rights are being protected and who are taking the benefit from the globalization. So, who are the winner of the globalization? And that is very important issue that we should deal with not only nationally but also globally. Next. And okay, the last one is that I would like to invite you to pay the attention concerning how the humanity for our daily work as a teacher, as a lecturer, how we convince, we persuade our students about the humanity in your daily process in educating, training, and also supervising them. Our students, as I have mentioned earlier, now students, but they would be leader in the future. And if we look into the situation, our student would be, after the graduate from the School of Law, they would choose the role. Could be lawyer with oracle of prophetic role. Could be lawyer as a legal reformer. Could be lawyer as humble clerk. Could be lawyer as pragmatist but wise. Could be lawyer self-reflective. But could be also media star and also the limo or even hired gun. I have many students who graduated from my law school. becoming media star, at the same time becoming hired gun. As long as you can pay, then you can use his knowledge, his skill, his network to win the case. Regardless the position, regardless about the justice, but the most important thing is that how to serve the rich, how to serve the people with handful of lucrative financial aspect. In this context, then we have the obligation how we confront them with humanity when they are students. Because it is the only opportunity to us to confront them. One day you would be a leader, one day you would be a lawyer, and then you have to choose your role. But remember, humanity in your perspective, humanity in your service, and humanity in your behavior. Because it is our obligation to preparing next generation of lawyers. Okay, next. Okay, I would like to conclude my presentation today by quoting two writers. One is from United Kingdom, writer we call Walter Savage, and many laws certainly make men bad, as bad men make many laws. Law could be good, could be bad. Another legal or law educator from the United States, Professor Oliver Wendell Holmes, in a very well-known statement that the great thing in the world is not so much where we stand as in what we are moving. That's my conclusion for this very brief presentation, and thank you to all of you for your attention, and thank you very much again, and I should stop my presentation here. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much, Prof. Sigit, for the great presentation. Please remain on stage. We invite Prof. Tongat as the Dean of Law to give the certificate and also souvenirs to Prof. Sigit. This is a certificate as a keynote speaker for Prof. Sigit, and also we have some souvenirs. And the last is Batik from Malang. Thank you very much, Prof. Sigit. Thank you very much, Prof. University. Please take your seat. Thank you. Ladies and gentlemen, the next session will be the first plenary session. We have Professor Hilary Tegnan, Mr. Hasnan Bakhtiar, and also Dr. Teng Junaidi Gunawan. And the session will be guided by Ms. Arum Puspitasari, MPD. So please welcome Ms. Arum.
warahmatullahi wabarakatuh. Okay, I know it's very cold here, right? It's chilling, yeah. So, but we need to move to the next sessions, Bapak Ibu. The next one we are going to have plenary sessions and maybe a bit of introductions from me. My name is Arum Puspitasari, and I'm going to be the moderator today for the first and also the second plenary sessions. Again, welcome in Malang. What do you think? It's a cold here, or it's just like so winter? Dingin, dingin banget. Yes. Okay. Ini dingin banget. Maybe the coffee will come after this, so just wait, yeah. But I want you to focus. And today, let me start the first plenary sessions. But before we start, I need to mention some rules to begin with. So we are going to have 3 speakers today for the first plenary sessions. And each speaker need to perform or present for about 20 minutes only, Doctor. 20 minutes, yes. And we are going to have Q&A sessions after that, after all the speakers finish presenting. And I'm actually not going to spill the tea, but the books are already here. For those who ask questions, we have a memento for you. This one is from Dr. Tang, and you're going to have this one. So you better keep your questions. Bapak Ibu sambil nulis nih lumayan ya, memento. And also, but we only open for 5 questions, yeah? Again, without further ado, I think we are ready to have the first presenter today. Yes, can we have Professor Hilary Teknen? I think it's going to be on Zoom. Is Zoom ready? Yep, okay. So let me first read the biography. So our first speaker is Professor Hilary Teknen, joining us, as you can see, online through Zoom. Professor Teknen is a visiting scholar at William and Mary Law School in Williamsburg, Virginia, USA. His research focuses on legal pluralism, land administrations, and corruptions in Indonesia. Professor Teknen's work explored the intersections of local and national legal systems, providing a nuanced understanding of how diverse legal traditions coexist and interact in Indonesia. So he basically knows a lot about Indonesia, yeah? And he has previously taught at University of Yaoundé too in Cameroon and has published extensively on topics related to the African customary law and legal also anthropology. Today, Bapak Ibu, he will be presenting on environmental technology, green tech, and the preservation of human rights. I think we are ready. Let's welcome together Professor Hilary Teknen.
Thank you very much. Firstly, this is the time to, I don't know if you can hear me properly.
Yes, Professor, we can see you here clearly.
Can you hear me fine?
Yes. Yes.
Is that okay? Okay.
Okay, yes.
Assalamualaikum warahmatullahi wabarakatuh. Please allow me to extend my gratitude to the Rector of Universitas Muhammadiyah Malang, Dr. Nazaruddin Malik, SAMC, and also to his many vices. Also, I would like to extend my gratitude to the Dean of the Faculty of Law, Professor Tala, which is I have the pleasure and honor to serve as a friend of mine, and extend my gratitude to the keynote speaker, Professor Sigit, Rianto, and the plenary speakers, also the panel session speakers. I would also thank the lecturers of the Faculty of Law, and thank the students, and last but not least, all the participants to this wonderful event. Today, I'll be presenting about the environmental technology or green tech and the preservation of human rights. As we know, human right is it's an issue we never get enough of discussing. It's constantly around the debates for many, many years, for many, many decades by scholars and also politicians. So, ladies and gentlemen, I think it's never enough to talk about this complex issue. In my presentation, I'll be highlighting the right to a clean environment. Second, I will be talking about the impact on environmental damage on human rights, and also gender-based discrimination in environmental-related issues. I'll also be talking about fighting the consequences of discrimination, and talk about the guaranteeing community participations, ensuring access to justice and environmental accountability, guarantee access to environmental technology to all. And last, I'll be talking about environmental education. It is very important. Ladies and gentlemen, you cannot talk about environmental issue in Indonesia without mentioning these, in my opinion, based on my research, some of the research, even if I'm based on the United States, have conducted substantial research on several issues related to Indonesian legal systems. So the result of these studies, I can see that so 5 major issues of environmental degradation that are worth pointing out. The first is the river pollution and hazardous industrial chemical in Citarum River. Excuse me if I pronounce that not correctly. In Citarum River, West Java. And this from the Greenpeace report of the 28/11/12. And also the forest and peat fire disaster in Sumatra and Kalimantan in 2019. The change of function of protected forests and agricultural lands. This is also happening in Indonesia too. Those who are familiar with the subject matter can see that these are some of the things, of some of the problems that have happened during the last decades. And also the water pollution by mining waste in Boywangi in 2023. This is the most recent one. And last, there's the excessive and illegal fishing in the Malacca Strait. So those who live on the island of Sumatra, especially around the Sumatra Utara, which is the North Sumatra, you have a sense of what I'm talking about. Ladies and gentlemen, next of my presentation will be, I'll give you an introduction of what I'm about to talk about. In recent years, the recognition of link between human rights and the environment has increased significantly. As I pointed out earlier, the number of scope and international and national laws and judicial decisions on the relationship between human rights and the environmental are rapidly increasing. Environmental technology is one of the applications of environmental sciences aimed at developing tools and biomonitoring and measuring the content of certain pollutants in air, water, soil, and etc. These tools generally aim for more economical and efficient solution and sustainable development. The problem that arise from these complex issue is so many states now include the right to a healthy environment in their constitution. Yet many unanswered questions remain regarding the relationship between human rights and the environment and require further explanation. As was pointed out by Professor Sigget, when talk about international issue, especially when it comes to environmental protection, there's a two-tiered justice here, or like he put it out, there's an hypocrisy that goes on here. Certain stronger nations tend to impose their rules and the way they see things on smaller or weaker nation, I should say, when it comes to the issue. And this is what I call the two-tiered justice when it comes to environmental protection. But the right to a clean environment, we have the right to a clean environment. Human rights to a safe, clean, healthy, and sustainable environment is enshrined in the 1945 Indonesian Constitution. So this is not some countries that are outside of the Indonesian transitional realm to decide which is best for Indonesian people, because the constitution provides for the safeguarding of the environment and also the a right for the Indonesian population to live within a clean and healthy environment. The laws of Indonesia also provide the same. The policies are also the same. You can see the national and regional level of the realization of the right requires guaranteeing a safe and stable government. So you cannot have a strong environmental law that complies with human rights without a strong and stable government. That's why it is important to have a democratically elected government that is trusted by the people. And that's the reason why the recent election in 2024 was closely monitored by experts. It was very important to put in there somebody who was democratically elected, as Indonesians is known for being the biggest democracy in the southeast region. So it was really important to monitor that. And I'm glad there was a rather legal issue to the ends of the elections in Indonesia. Ladies and gentlemen, environmental protection is a necessity. It's a necessary condition for the effective enjoyment of human rights enshrined in the treaties, including the International Covenant of Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. So it is not just about legal issues, it's also a cultural right. And the next part that I would like to bring to your attention, ladies and gentlemen, dear participant, the impact of environmental damage on human rights. The obvious consequence of environmental damage often affect those who are least responsible. So you have big corporations that really pollute the environment to the detriment of the weaker, those who have lesser power or no power at all, those whose voice really doesn't count. So this is what it's all about. The people that are in vulnerable situation who are limited resources to deal with them. Environmental polluting can cause health problems like respiratory diseases, heart disease, and some type of cancer. People with low income are more likely to live in polluted area and have unsafe drinking water. Environmental destruction caused by people lead to violation of human rights. So due to our time constraints, I'll pass on some of these points, but the most thing to stress on is that the destruction of the environmental of the environment is a violation of human rights. From that violation unfolds a series of problems like health issues, the enjoyment of a safe environment, and also the good use of natural resources. And we can see here too, there's also discrimination going on too. It's not just about big company polluting the environment or overexploiting natural resources too. There's also a discrimination that goes on in this phenomenon. Discrimination based on gender. This is the biggest and most not noticeable. It is prohibited by all main international human rights. International law requires the government to make measures to modify or repeal laws, regulation, customs, and practices that constitute discrimination against vulnerable community. This discrimination results in unequal share of power, as well as within the family and society. Limited access to productive and national resources reduces access to information and restricted decision-making power. It has also taken the form of laws, social norms, discriminatory practices that can lead to violence. So how do we solve these things, ladies and gentlemen? The solution is to combat discrimination and gender-based violence in environmental context. The government should revise, modify, or repeal policies, laws, and practices that create, perpetuate, impact on environmental policies. And we have here the how to understand the fighting and the consequences of this discrimination. Environmental crisis amplify gender inequality and aggravates intersecting forms of discrimination, particularly in the function of of socio-economic classes, religion, or belonging to an ethnic, racial, or indigenous minority, disability, age, migration status, and sexual orientation, gender identity, or sexual characteristics. The people confronted with these multiple and intersecting forms of discriminations are often disproportionately affected by environmental damage. When making laws and policy, it's important that the government works to address intersecting systemic inequality and takes concrete steps to remove barriers to participation and leadership of women and the vulnerable citizen who experience intersectional marginalization and discrimination. This measure may consist of guarantee equal access to information, participation, remedies, investing in systems of social protections. These are very important too, ladies and gentlemen, that the measure. Why am I really focusing on the government here? Because the government has the keys. The government has all the power and also the instruments to go after those who commit. Like I pointed out earlier, this damage is not committed by the people at the bottom. It's always the people at the top, the people with big resources that really commit that. So the average citizen cannot go on their way to try to tackle or take down these big corporations. It's going to be a fight that is already lost even before it started. And how do we guarantee the participation of community? Regional or international human rights instruments enshrine the right to equal, free, active, meaningful, and informed participation of the population. That's the rational or the international norms. The government also are pressured to undertake gender-sensitive capacity building awareness or raising and monitoring efforts, and put in place positive measures to remove traditional barriers that limit the participation of women and gender-divided people, basically people with vulnerability. These measures should include enshrining gender parity, ensuring that negotiating team on environmental issue have adequate expertise on gender issues, and establishing concrete participatory processes that include vulnerable community members. Now, how do we ensure access to justice and environmental accountability? Under the International Covenant on Civil and Political Rights, states are required to ensure that non-discrimination in the access of all people, regardless of gender, to justice and legal remedies for right violation. Effective, flexible, and gender-sensitive accountability mechanisms are essential to combat the human rights consequences of environmental damage. The government should remove barriers to access to justice and environmental matter. The government should also encourage cooperation with non-state actors, including non-governmental or local organizations which plays a key role. The government should also reform and repeal policies that contribute to an unequal distribution of resources. To meet this obligation, business should not violate human rights by causing environmental damage and should address negative human rights impacts for which they are responsible. Then I have a couple more slides before I can end my presentation. And also guarantee access to environmental technology. This is very important too. These days we have the advent of AI. AI is overtaking the world now, so it should also be brought to the fight against environmental pollution, and violation. Article 15 of the International Covenant on Social, Economics, and Cultural Rights recognizes the right of everyone without discrimination of any kind to benefit from scientific advances in their application. The government must ensure that scientific advances are accessible to everyone and that everyone has the opportunity to build a better and more sustainable future, including people or groups who are marginalized and in a situation of vulnerability. To enable all women and everybody that finds themselves in a vulnerable situation, including indigenous women, to realize their right to benefit from scientific advances and their application, states or government might cooperate with private sectors at the international level to determine the needs of the community. The government should also invest in research. This is very important. In research that documents the role played by gender identity in shaping differentiated vulnerability to climate change and environmental degradation. Last, like I pointed out at the outset of my presentation, I will be discussing one important point, which is environmental education. The education of women or people in a vulnerable situation, particularly on environmental matter, is essential to encourage their contribution to environmental actions and to strengthen the resilience of the community in the face of environmental damages. The government or the states should guarantee equal access to education from nursery school to university for vulnerable community and ensure that access to education is guaranteed even in the presence of environmental or climate risk. The government should direct educational programs toward eliminating harmful gender stereotypes and developing the skills and knowledge necessary to report and protect the environment. Ladies and gentlemen, this is the conclusion now. Sustainable development is evolving with more restrictions, restrictive environmental regulation, and booming environmental technology markets. It requires the development of eco-responsible management of approaches as well as technology capable of combining sustainable development, circular economic, and innovation. The government, businesses, international organizations, and other actors have material and legal duty and responsibility to address environmental crises under international human rights laws, international environmental laws. To address this crisis, the government must prevent adverse consequences on the enjoyment of human rights and ensure that measures taken to combat environmental degradation take human rights issue into account. Ladies and gentlemen, my takeaway is protecting human rights means protecting the environment. Without a healthy environment, we cannot realize our aspiration or sometimes even meet minimal standards of human dignity. Thank you so much. Terima kasih. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi. Terima kasih, Bang. Tiba-tiba ingin bahasa Indonesia ya. But I really like the takeaway from Professor Teknan. Protecting human rights means protecting the environment. Yes, we need to take action for this one. But again, before you raise hand and give the questions, we're going to welcome the second speaker for today's discussion. Also, it's still conduct online, Bapak Ibu. But the next one, we have Bapak Hasnan Bahtiar. If you joined the last INCLAR, fourth INCLAR, you may recognize him sitting here, yeah, also as the moderator for the INCLAR last year. So Bapak Hasnan Bahtiar is the Master International, from Deakin University, Australia. He specialized in politicians of informal religious law. So if you have any interest in religious law, I think you're going to love this presentations and its role in populist mobilizations in Indonesia. His research highlights the interplay between informal legal system and formal political structures in Indonesia. Again, I'm not going to mention because we have long list for the published research. But let me call now Bapak Hasnan Bahtiar, who is going to present the politicians of informal religious.
Hello, sorry.
Oh yes, Pak Hasnan. Where are you? Oh, where are you?
Yeah.
Ready, Pak Hasnan? Oh, is that checking the signal?
Okay. You can hear me?
I can hear you very clearly. Audible, Bapak?
Okay. Can I send myself?
Sure, sure.
Okay.
Okay, but please wait. Now we cannot see the slides of presentations. Do you mind waiting a bit?
Can you see my slide?
Yes, now we can see it. Ready, Pak Hasnan?
Thank you very much.
Okay.
Assalamualaikum warahmatullahi wabarakatuh. Baru terima kasih Profesor Tolat, Profesor Salis, Profesor Siti, Profesor Hilary, Profesor Toke. Opportunity. Thanks for allowing us to our research on the politicization of informal religious law and populist mobilization in Indonesia. This research Trial and Research Council, ARC, under Discovery Grant, Religious Populism, Emotions and Political Mobilization, Civilizationism in Turkey, Indonesia, and Pakistan, and with the specific subject main part of my research.
Pak Hasnan, I think we got a problem with the signal. It's a bit
Please.
unclear. Hello, Pak Hasnan? Probably if the signal is not that good, do you mind turn off the camera a bit? Probably. Ya, kameranya dimatiin dulu mungkin Pak Hasnan. I think because of the signal. Oke, kita tunggu ya, Bapak Ibu ya. Let's wait a bit.
Okay, can you see my screen?
Yes, I can hear your voice too.
Okay. Okay. But it was re-established in the year of 2021 after planning by changing its name, logo, and etc. to the Islamic Brotherhood from its new version, the new FBI has been ideologically one. So, is my screen moving? Can you see my new screen?
Yes, Bapak. Now on the second slide.
Okay. I mean, next screen. We propose now. No? Okay. In terms of its involvement in the contestation of our practical politics in Indonesia, the FBI was seen as still very influential. Well, in the context of the complex political dynamics in the country in which the FBI faces the political difficulties, for example, it was banned its activities, including social media and more broadly in was prohibited by the police, and it's kind of a practice of some sort of digital authoritarianism by the ruling government. 6 Laskars were killed by the members of the police, and its grand imam, Rizik Sihab, was imprisoned, then released on parole, and now totally free. And
the FBI is still very important extra parliamentary political force that can have a strong impact on the 2024 election. Uh, the FBI is known as Islamist but Intolerant Movement by Fakal 2020, Islamist Populist and Vigilante Movement by Fedi Hadis in various of his publications, Robinson, Mitzner, Muhtadi, Aspinal, and etc. But Barton and Yilmaz describe the ideal expression of the FBI's populism. By the South, its populist to as Islamist civilizational populist.
Hasnan? Okay, got a bit problem with the signal again. Bapak Ibu, please kindly wait. Okay, maybe this is a problem with the camera. Yes, finally. Yes, Bapak, we can hear you. It's gone back again. Okay. Okay, while waiting, please enjoy your coffee. Okay. Also, we got some snacks in front of you, Bapak Ibu. Okay, I think we're still waiting for Pak Hasnan to join back.
Okay.
Okay.
Can you still hear me?
Yes, now you're audible, Bapak.
I'm so sorry because the maybe is the connection is not that good here, but let me try to emphasize what's important here. The FBI perceives that the elites are not only the enemies of the pure people, good people, but also who are in cahoots with the dangerous others who belong to the social and cultural identity of a certain civilization that's considered threatening to the civilization of the people. While scholars have enthusiastically investigated the driving forces behind the emergence of this type of religious populism, and others have developed theoretical categories, Yilmaz has extended his analysis to the mobilization aspect of populist politics, in particular the empirical explanation of how religion becomes a political instrument that supports populism. But regarding the issue of what specific elements of religion are significant in the process of political instrumentalization that supports populist mobilization, remains a gap to be filled. So we investigate the Sharia elements of Islamism. The FBI's activists grasp them strongly as the main ideological core of their populist contents. We also analyze these elements within the theoretical framework of informal religious law, which applies in the context of a Muslim society. Accordingly, our study focuses on how the FBI instrumentalizes informal religious law to support its Islamist civilizational mobilization. Our research was based on qualitative data collected in the 6 months leading up to the election on 14 February 2024 until 15 March of that year. This time frame refers to the bulk of
the political campaigns where political lobbying takes place until a month after the election, when critical voices emerge on the crucial issue of fraud, for example. And this data consists of the speeches of the FBI leaders, as mine figures, such as Muhammad Rizik Sihab, Hanif Alatas, and others, press releases published on its website, propaganda articles published, and political statements disseminated through its social media, especially Telegram and YouTube. The data were analyzed using the civilizational approach to populism, elaborated with the theory of informal religious law, which focuses on the issue of the FBI's instrumentalization or politicization of informal religious law in its populist mobilization in the context of the 2024 elections in Indonesia. We specifically look at the informal religious law that we identify its embodiments as the discourse of Sharia, fiqh, and fatwa. Then we look at the context of the informal religious law embodiments that can enrich our understanding on the FBI's empirical security. We also analyze the ways in which the FBI constructs and delivers the informal religious law, which is combined with certain empirical messages. Next, please. Okay. By civilizational populism, I refer to Yilmaz and Morrison's theory, 2023, and they define civilizational populism as a group of ideas that together considers that politics should be an expression of the general will of the people, and society to be ultimately separated into two homogeneous and antagonistic groups: the pure people versus the corrupt elite, who collaborate with the dangerous others belonging to other civilizations and who present a clear and present danger to the civilization and way of life of the pure people. And by informal religious law, we mean a legal entity outside the formal legal system of the state, and the people of that state uphold and respect this law as it governs all aspects of their lives. In the context of Muslim societies, it is Sharia, fiqh, and fatwas. Next, please. Okay. The current election presents a contest of practical politics, with Prabowo teaming up with Jokowi's son, Gibran Rakabuming, against Anies Baswedan, teaming up with Muhaimin Iskandar, and Ganjar Pranowo to simplify alongside Mahfud MD. In the context of the complex coalition of Indonesian political parties, the FBI as an extra parliamentary force decided to support Anies Muhaimin. And this support shows the consistency of the FBI's political preferences for candidates who are seen as a pro-civilizational Islamist populism and on the side of the Ummah. Rizik Sihab said that Anies Muhaimin has the support of the Ijtima Ulama. He advised Muslims to vote for the candidate chosen by the Ulama. He said, we ask ulama out every matters and make ulama our place of inquiry. We should ask also ulama about voting leaders. The FBI by the political Prabowo and Gibran camp, especially to Jokowi's political power. These include the perpetuation of Jokowi's political dynasty, legal manipulation by the constitutional court, abuse of authority and power as a state official, and vote counting fraud, and etc. Can you move, please? I think this is the main dish here. FBI bases its political decisions on the findings of the Ijtima Ulama, an institution made up of ulama with Islamist ideologies from different regions of Indonesia, who are tasked with carrying out collective ijtihad, legal reasoning in the political sphere. Rizik Sihab stated that political decisions must uphold the principle of deliberative consultation. It's a musyawarah in Bahasa Indonesia as a religious commandment. There is a legal dimension within it based on the passage in the Quran, Surah Ali Imran, and deliberatively consult with them in all important matters. Washawirhum fil amri. So the phrase and deliberatively consult with them is seen as a command from God, the scripture, as a very important part of Sharia, which contains an element of obligation to fulfill it. The Ijtima Ulama Forum, attended by ulama and leaders from various regions, was held at Azikro Sentul, Bogor, on 18 November 2023, in the forum led by Kiai Haji Muhyiddin Junaidi. Would you please next? And moderated by the chairman, Muhammad Hussein Alatas. Just one more slide, I think. The ulama listened directly to the presentations of Anies Baswedan and Muhaimin Iskandar's political vision and mission. The forum resulted in decision by the Ijtima Ulama to support Anies and Muhaimin in the 2024 presidential election. They demanded that this endorsement be understood as the religious trust, Amanah Ijtima Ulama, which is based on Sharia principles, implies a legal obligation to comply with it and not violate it. On 13 December 2023, Anies Muhaimin an integrity pact between points, the essence of which was that they must side with the Ummah and at the same time fight the enemies of the Ummah, emphasizing that they are anti-secularism, anti-Islamophobia, anti-Islamophobia, terrorism, separatism, imperialism, communism, Marxism, Leninism, religious blasphemy, immorality, LGBTQ+, prostitution, alcohol, drugs, and others, Zionism, racism, fascism, corruption, collusion, nepotism, and a lot of ism here that perceived as evil. And it is also emphasizes their support for the ulama moral revolution, akhlak, economic sovereignty of the people, support for the poor, human rights, especially civil and political rights, and land reform. Based on this Ijtima Ulama result, and since the signing of the integrity pact by Anies Muhaimin last year, until a few days before the election, 7 February, the FBI ideologue, Hanif Alatas, had campaigned to mobilize the masses in various regions, such as Jakarta, Banten, West Java, Central Java, Palembang, Riau, East Kalimantan, and others. In his campaign, he called for the same thing, very consistent assertion. Ready to follow the command of the ulama, ready to follow the ulama who are highly consistent, highly istiqomah, ready to follow the direction of the Ijtima Ulama. We obey the Ijtima Ulama. 2024, Anies becomes the president, takbir. And finally, on 8 February 2024, the FBI held an istiqosaku pro religious gathering at Benyamin Sueb Stadion, Kemayoran, Central Jakarta, which was attended by tens of thousands of people. At this moment, Rizik Sihab called for the election to be direct, general, free, and secret, as well as honest and fair, in order to create peace. He also warned that they were ready to fight if there was any fraud in the election. Since, according to the FBI, there has been political fraud, especially committed by the Prabowo Gibran party supported by Jokowi, the FBI mobilizes the masses to fight against the fraud. Rizik Sihab, for example, calls on the masses to fight the political fraud that's taking place, while at the same time building mass confidence that the pure Ummah can win against Ahok in the 2017 gubernatorial election, even though it was not supported by large political force. According to Rizik Sihab, the FBI's opposition to political fraud and confidence in preventing evil is part of an effort to uphold the God's law, the Sharia. Would you please to move the slide? Okay. He said that, well, because of that, if you want Amin and his Muhammad twin, that's why I invite you. Let's fight fraud. Don't be afraid. If there are other candidates supported by economic power, political power, we have experience in Jakarta. In Jakarta, when we fought Ahok, what did we have? Ahok was supported by the president, the chief of police, supported by the TNI commander, supported by all mainstream TV media, supported by major parties, supported by Taipan conglomerates, supported by the Nine Dragons, supported by survey institutions, brothers. Those who support Anis at the time were only parties, brother, whose votes were actually not as big as the parties that supported Ahok. Ahok was backed by foreign powers, brother. On paper, Ahok won. But what happened after that? It turned out that God's will was different. Allah subhanahu wa ta'ala still forced Ahok to resign. The Muslims won, brother, right? Takbir. If we obey Allah, we don't have to worry. In tansurullah yansurkum. If you defend Allah, uphold His law, and uphold His Sharia, yansurkum. Surely Allah will win you all this. Allah's promise is sure to be true. Allah's promise is impossible to miss, ya ikhwan. And let's move on to the conclusion. The FBI uses informal religious law as an ideological expression that supports its political mobilization, while the expression of ideology itself is part of the da'wah effort, revealing the truth, commanding good, as well as preventing evil, and getting closer to God. From the FBI's political perspective, informal religious law is an instrument that supports their populism. This acts as a religious justification that constantly and convincingly offers option. I just remember that the way of thinking in Islamic legal theory, shown by a legal maxim that al-aslu fil amri lil wujub wala tadullu ala ghairihi illa bi qarinah, which means basically the imperative assertion in Islamic law, in Sharia law, leads to a legal consequence of being obligatory to conduct. And its exception will not be ruled unless the raison d'être emerges. So it's quite similar with the legal maxim in Latin, actus nemini facit injurian, which means the act of the law does no one wrong. So and the instrumentalization of informal religious law in the populist mobilization underlines that populism is the only right solution that must be implemented. We also find that the FBI uses its informal religious law in two trajectories to support its populist mobilization. First, it engages with the performative elements of populism. And the second is it uses informal religious law as ideological expression. This has to do with the legalistic nature of Sharia law, which has nuances of halal and haram, black and white, right and wrong. And meanwhile, according to the FBI's Sharia-centric perspective, politics tends to be positioned as a field of da'wah. Thus, politics must have a religious mission. If there is a concept of Islamic politics, then in this context, it's Sharia-based populist politics. So, last but not least, my reflection regarding this study, this conclusion invites a question on the possibility to identify an alternative pattern of the civilizational populist mobilization. So it seems that in the case of the FBI is showing not only the pattern of instrumentalization or politicization of religion, but also religionization of politics. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Pak Hasnan. Now again, just to maintain the time, beside me, a very handsome opa-opa ini ibu-ibu, biasanya manggil opa gitu, if you love Korean drama. So we have Dr. Teng Junaidi Gunawan. Well, he is an alumni of Universitas 17 Agustus in Surabaya. And I have a message from Dr. Teng, nggak usah panjang-panjang gitu, for the biography. So let's just welcome, he will discuss the human criminal deterrence formula through restorative justice and economic analysis of penal law approaches. It's going to be a great discussion. Yes, please, Doctor.
Yeah, before I begin, did you already get the slide, the share slide? This one? Sorry, you can copy from this QR code to download the slides if you want.
Yes, mungkin because you know the screen behind us is different with the one that we see on the screen. Mungkin bisa dibantu yang di belakang untuk menayangkan QR code-nya. Yes, that one. I want you to use your phone, Bapak Ibu, now and scan it. You'll directly go to the presentations.
Okay, enough? Let me begin. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya. Good morning everyone. My name is Teng Junaidi Gunawan. Today in this 5th International Conference on Law Reform by Universitas Muhammadiyah Malang, I'm presenting the result of my research on human criminal deterrent formula through restorative justice and economic analysis of penal law approach. Sorry. Yeah. My special gratitude to Prof. Tongat, the Dean of University Muhammadiyah Malang, for the invitation to this conference, and to the honorable mention, Prof. Sigit Rianto. I'm sorry for the unupdated slides, and Prof. Najij and Prof. Hilarie Tengnan, and Associate Professor Koke J. Fernhorn. Sorry if I'm pronouncing it mistaken. Professor Hasnan Bastian and Professor Jadi Hasdi Jadi Saldi Hashim. I'm sorry. Yeah. This is the following are the table content of my presentation, which is according to the submitted paper. But due to time limit, I will present it only the important parts. Next. So let me introduce myself. My name is Teng Junaidi Gunawan. For the highlights, I'm a master. I did my master degree on Universitas Bhayangkara in 2014. and then I finished my doctorate degree on 2021. I also create the author of the books in Indonesian language, but in English title can be easily translated as economic loss value-based sentencing concept, and the second one is the equivalence value between imprisonment and fine sentence, and then the last one is the restorative justice-based sentencing that has criminal deterrent and responsive. And this is our journals and other writings that I did. So it began with the doubt that current criminal justice system or penal law is able to achieve criminal deterrent. I propose a simple test. Pick any criminal code to test that should be have a specific number for maximum imprisonment sentence. Second, try to find the highest economic damages ever caused in real life or in theoretical sense. Third, assume that the object of the crime is forever lost and the perpetrator is unable to pay back the damages. I'm sorry. Fourth, assume the verdict for the perpetrator is at the maximum length of imprisonment of the criminal code. Then compare it with other person who works legally in the worst condition with the same length of maximum imprisonment could get the same amount of money equal to maximum possible benefit of the crime. Most of the tests found unable to reaching it. This shows even at the maximum threat specified by criminal code or articles is unable to outweigh the benefit of the crime. So for this example, I choose a luxury car, which is a Ferrari 812 Superfast, which is in 2020 ranked as the second cheapest in Indonesia in a value around 4.5 billion rupiahs, or roughly 280,000 more US dollars. For ordinary Jakartan people in 2024, it will need like 74 years, 7 months and more. It assumes neglecting the inflation of the damages and therefore also neglecting the future increase of the minimum wage. So the research that I did includes the resources from Indonesian's current KUHP, Indonesian's 2023 KUHP, Netherlands Civil Code WVS 2012, and American US Sentencing Guideline version 2023. In most criminal justice system or penal law in this world, the criminal liability weight is separated into two liabilities. One is the penal sanction or criminal sanction, and second one is the civil law or civil sanction or tort law, tort sanction. In most, victim losses or damages compensation does not add to the criminal liability weight, while tort or criminal law sanction is currently limited by basic human rights. So, let me have an example for Indonesian KUHP for theft in Article 362. The simplest way to translate it is the threat maximum is 5 years in prison or 1900,000 rupiahs or 6 months in jail, confinement. I'm sorry. Yeah, this should mandate that the lowest one should be the right for every inmates or every perpetrators, but that's not the case. We just goes directly to the imprisonment. And for the 2023 KUHP, it's actually better, which is total maximum can be 10 years, which is 5 years for the fine if non-paid, and additional 5 years if the victim compensation is not paid. So this is the additional or the improvement of the KUHP 2023, where restorative justice is being implemented and double track or dual track system in Netherlands is being implemented here. Next, and I skip this one, right? So this is the sentencing structure of 2023 penal code. Yeah, this is better, but actually there are problems such as irregularities between the weight of prison sentence and the fine sentence still appear. For example, look at this. The life, criminal type, and if you see the fine sentence category is same with the moderate one, which is 2 years with or 50 million fine, and 4 years with 50 million fine. Well, I don't have the time. So, yeah. So this is also in the Netherlands. The problem in Netherlands also shows similar condition with current Indonesian KUHP. So 5 years imprisonment or 19,500 euros. Yeah. While in my calculation, if we are using the regional minimum wage of the Netherlands, which is in 2012 valued around 1,449 euro, yeah, 49.5 euro, it should be around 96,432. So yes, it's still unable to catch the amount of damage that I present earlier, which is 4.5 billion. Wait. This is the United States sentencing guideline, which is the United States penal code. It also has that kind of weaknesses, which is irrationality between the imprisonment and the fine, and how it set the code where a lot of damages can be paid with a small fine. For example, in the loss category, more than 500 million US dollar, with a maximum possible offense of 36, which is maximum fine sentence only 400,000 US dollar. So 550 million can be paid with a fine 400,000. I don't know why. And if we consider the minimum wage in the United States, the 405 months imprisonment for that kind offense level will only valued around $462,800. And it's things that need to be see that the limit of damage according to specified provisioned categories in this case, even if 550 million, if you have a condition where the damages is more, for example, 5.5 billion dollar, it's still the same amount of weight of sentencing. I'm sorry. Yeah. Okay, this is the table I'm showing. It's from my other journal. We can see the irregularities here. Now go to the theories. As I mentioned, this research using economic analysis of law and restorative justice. And it's actually supported as well by Jeremy Bentham, which is any crime at least have two factors, which is the primary mischief and secondary mischief. The primary mischief is the victim losses And the secondary mischief is the mens rea, or the projection of the guilt. So basically, I'm arguing that Jeremy Bentham's sentencing formulation is also supporting retributive sentencing, because without following the formula, there will be no way to actually achieve the rehabilitative justice. Sorry. Next, yeah, wait. It's also supported by Kant, retributive justice, and at the most modern theory, which is the just desserts theory, which requires the proportional between punishment and the damages it causes. But somehow, from my study, I didn't find any related or formulated solution in this theory. Next. So it also includes John Rawls' theory of justice, which is asking for fairness, which is treating all equal or equally in an equal formulation. Another thing that is important, I think, for in the John Rawls theory is about humane treatment, which is guarding to limit the minimum treatment that can be given. Therefore, a criminal deterrent is important to treat the inmate in a just and human condition. So here I am trying to argue that because the formula for human values, yeah, is not purely described. So in this case, I'm presenting human value is a treatment that is aimed to maximize the dignity and civilized treatment for any person. Second, any ill treatment or punishment, any revocation of personal rights must be clearly defined and rationally explained. Or in other words, to minimize the pain inflicted as reciprocal action of the perpetrator's prior act. Third, preserving the liberty or rights to choose and the right to improve. I think I skip this. Let's go directly to the conclusion. So the proposed human criminal deterrent formulation showed the evidence that criminal deterrent can be formulated in a mathematical equation using economic variable to formulate in a just and human criminal deterrent formulation. The formulation ensures the punishment of criminal sanction weight that must be greater than the crime's profit, as required by one of Jeremy Bentham rules. This gives a formulation that gives meanings, certainty, and economical reasonability for the imprisonment. This formulation proposed: A. Imprisonment should be treated as a forced labor equivalent to the economic value gained by any person working legally in the worst condition in that area and time period, represented by economic variable, namely regional minimum wage, which ensure the priority for perpetrator to choose imprisonment as the last resort. And B. Implementation of criminal sanction, especially imprisonment, must be done in a just and human way, which 1. Should avoid meaningless infliction of pain and misery. 2. Shifted toward a meaningful, just, and reciprocal sanction and formulation. 3. The option to avoid or reduce imprisonment is equal valued benefit or good deeds. A suggestion: as part of the 5th International Conference Law Reform, especially in criminal justice, this study suggests refining humanity values through a law reform that is based on an attempt to provide justice to all parties through the reserve engineering attempt from economic analysis of the law. This formulation is to ensure a minimum standard that is humane, meeting its purpose, and responsive through all the passage of time by implementing a formula that is derived from the existing economic variables. Second, to use economic variables such as minimum wage to ensure the formulation will be self-responsive and with the increase of current economic condition localized in a specific area. Thus, it is possible to formulate a responsive law according to Philip Nonet and Philip Setnik to achieve it. And this is the, wait, what happened? Look. Oh, I'm sorry. So this is the formula that I am presenting in a mathematical formula. I'm sorry, the slide didn't move. So this is my last presentation. Thank you.
Okay, let me test. Okay, it's back. Thank you so much, Bapak Ibu. And I know the discussion is actually plenty, but the time is limited. But let me tell you, you can get like more detailed explanations in this book. So please now, let's move to the second sessions. We will now open the floor for some questions. We got one back there. Yes, can I have, okay. So Bapak, can you please tell me your name and where are you from, like the university?
Okay, I'm Benny Setianto from Sugiyamanata Catholic University in Semarang. I would like to ask a comment from Professor Teknan. If hopefully he's still here, right?
Well, he's supposed to be here still. Hello, Professor Teknan?
Professor Teknan, are you?
Yes, I'm here.
Okay, sure. Professor Teknan, I would like to invite your comment on two things. One thing is in relation to the linkage between the environmental rights and human rights. You mentioned some occasion and some events that relates to those two terms. Can I use environmental justice as the terminology to linkage between those rights in a sense that using the environmental justice, then we can react more and move further rather than try to combine between the environmental rights and human rights. That's my first comment from you that I heard. I would like to hear it from you. The second comment that I would like to ask is, what about the role of the human rights defender? Because sometimes when we touch the environmental rights, we only consider the victim on the casualties of the environmental exposures. But there's other roles as the human rights defenders that they might not directly affected by the environmental exposures or hazard exposures, but they still have an important role, in my humble opinion. Thank you.
Thank you, Pak Ben. I think let's just get the answer ready, because if not, in 5 minutes I'll start forget the questions. Oh. I'm sorry, the battery is also tired. Yeah. Let's have it. Professor Teknan, can you please give response directly for this one? The linkage between human rights and also environmental rights?
Right, sure. Without to this term of patients, if I get it right, you mentioned the two terminology between environmental justice or environmental rights with regard to upholding human rights. I think when you refer to environmental justice is to right the wrong done by any entity or any company that has done some activities that are deemed harmful to the environment. So if you want to consider that, so if you want to use the terms environmental justice, it would be to restore or to bring the conditions where the states of everything was they used to be. When you talk about environmental right, that's something else. It's right is something you can claim. Right is something you are entitled to. Like I pointed out in my presentation, I mentioned the Indonesian constitutional, the 1945 constitution that makes environmental protections and also living in a safe environment in Indonesia as a constitutional right. So if you're talking about terms of rights, then you might want to use environmental rights. But if we talk about restoration or also uh, right a wrong done by an entity or a companies that maybe conducted some activities that destroy or have harmful impact on the environment, that you might want to ask for justice in this term, environmental justice. So these are two separate realms, separate terms that you might want to be careful using. And when it comes to a human right here, you might want to use because in my presentation I talked about the right. I focus on the right, environmental right related or connected to human rights. The right to a safe environment, the right to information sharing, the right to to make use of the resources available to the population. So in this term, there is a connection, a direct connection between human rights and environmental right. As far as environmental justice is concerned, in my opinion, it's not necessarily linked to human right because is it's justice is, I would say, it's not absolute. It's not what I would say it is not objective. It depends on the party. So you can't say uh, environmental justice may be linked to human right. When human right here is something that is universal, there's no such thing as universal justice. If you understand what I'm trying to portray here. And moving to your second question, you say the role of human rights fighter or human rights defender. Um, I'm not sure I understood your question correctly, but yes, you said it. What, if I'm not wrong, so what was the role? What's the role of human rights defender or fighter, or which terminology should be used? I would say human rights fighter, defender. I think this is they're all the same. It's the same thing. If you fight for something, you defend that thing. So they are possibly doing the same thing. They have the same role. Correct me if I get your question wrong. You might want to reshape that question again so I can provide a better answer to your question. Thank you.
Baben, do you want to clarify for the questions? Make it. Yes, the second one.
Yep, Professor Taylor. First of all, thank you very much for your comment for my first invitations. For the second questions, when you mentioned about the environmental exposure, especially the environmental hazard to the people, then you focus more on the casualties and the victims of the environmental hazard exposures. That's why I asked your comment, what's the role of the environmental human rights defender? Because they're not directly affected by the environmental hazard exposures, but they play an important role to defend the right of the community. And that's the link between the human rights and the environmental rights. What's your comment about that? Thank you.
Yeah, thank you. I think it's, it's a very clarification and also it creates kind of like very nice conversation between human rights and also the participant. Here you have to know something. Human rights, these are rights that apply to those that are less fortunate, those that are weak. But given that classification, you already know that if they are weak, they cannot initiate any action to seek for justice without the help of some kind of entity. That's why NGO comes in here to play that role. They have limited access to tools, to information, to platforms. So they need to have these entities, like you pointed out, environmental fighters or environmental defenders. The role that these entities of these individual play, it's immense, it is tremendous. It is because of them that companies are being held responsible for their action. No farmers in a remote village is going to say, okay, I'm going to take down this company on my own without the support of these
entities you label as environmental fighter or environmental defender. The government here, you need to understand if the task to take down or to tackle this entity were left to the government, there's a great chance that not much will be done because sometimes corporation companies, they work hand in hand, they share power with some government, especially in government where in countries where you have dictatorship or you have some kind of government that really don't uphold the rule of law and democracy and human rights, they work for the government. So if you leave that to the government, there will be no chance, zero chance for the vulnerable people to be defended, for the vulnerable people to have their voice heard. So this is where environmental fighter or defender, this is where they squeeze in, which is they come in to create accountability, create justice. I think I endeavored to give some response to your question, Mr. I like your question. It's very straight to the heart of my presentation.
Okay, I think that's enough, yeah, Pak Ben. Thank you so much. Thank you, Prof. Let's move to the second question. Bapak, Ibu, I know you have enjoyed your coffee. Okay, yes. Can I have it, Pak? Yeah. Can you please stand up, Bapak?
Hello. Thank you so much for this opportunity.
Okay.
My question to Professor Ferdinand.
Again.
As we know, Professor, the intergovernmental panel on climate change in 1990 mentioned that the biggest impact of climate change is the increase of people around the world. Many efforts have been made by the international community to overcome this problem, but are often still fairly weak and do not have sufficient political capability to handle it. As a result, the climate refugees are not recognized by international law and United Nations. Saying this problem, I want to know from your point of view, does a national law or policy have a big role and influence in encouraging international law and United Nations to recognize the existence of climate refugees? For example, as we know, New Zealand has recognized the existence of climate refugees. I want to ask second question for the...
Oh, I don't think we can have the second question. Yes. But can I have your name, please, and also the institution?
My name is Ahmad Sabirin. I'm from Trisakti University, Jakarta.
Okay. Yes, okay. I hope you're still here, Professor. It's about the relations of whether the national law also able to influence, if I'm not mistaken, yeah? Let me know, the international law. Yes, please. Professor, probably just 5 minutes for this one. Okay, do you mind waiting ya? Kita tunggu bentar ya. Oh, others maybe? Probably. One more question, Bapak Ibu. Ibu-ibunya belum nih? Ibu-ibu? Yep, please. Anyone? Okay. Ibu, please.
Stand up.
Yes, yes, Ibu boleh stand up. Yes.
Thank you. Assalamualaikum warahmatullahi wabarakatuh. Thank you for the opportunity. There is a big great in here in class. My question for Prof. Hillary Technique. Yes, as we know that in U.S. Constitution, not include in there about the related the relation between human rights and environment. So, if you not mind, please explain about the, is it now the amendment of UN Constitution, I'm sorry, US Constitution, is it include in there about the mention the environment and the right about the life, liberty and property?
Thank you.
Thank you.
Doctor, it seems like today we have a lot of, from law department interested in environment. Okay, but we are still waiting. Bapak Ibu ya, hopefully. Professor Hilary, you're still here.
Yes.
Okay.
Whatever, reframe me the questions because the audio was so bad from my end here. I couldn't understand.
Okay, which question, Prof? Should I mention both?
Did I receive two questions? I think I only heard the lady that just spoke.
Oh, I think you missed the previous one. We have two questions. The first one is about whether the national law, correct, can influence
okay.
the national law. That one?
Yes. Yeah. I didn't know it was directed to me. I thought it was to someone else, to one of the speakers. I got that question, and also I just wanted a little clarification too. But anyway, due to time constraints, I've answered the first question. You have to see that laws are very different. There are hierarchy in the law. The question is whether national law prevails over international law or vice versa. What I will say in a simple answer is, for a sovereign nation, laws that are enacted within that nation are supreme. They are above the international law. But then again, it's going to depend on whether that country or that nation has binding international treaties, maybe is part of these international treaties. So let's say, for example, if Indonesia had signed the Geneva Convention, for example, if you sign, which means you are willing to relinquish or to give way to that treaty to be applied to your country above the national laws. So it's very tricky here. You have the national law that are very sovereign and supreme. But if the country is a part of the international treaty or convention, these treaties or convention applies to that country regardless of their national legislation. That's how I can put it. And then for the second question, the lady mentioned that in the U.S. Constitution, there is no link between the human right and environmental right. There's no mention of that. I don't know if I get that correct, but I'm no expert in the U.S. Constitution or U.S. constitutional law. But what I can say is, in U.S. legal system, you have something called, you have the federal government, and you have the states. You have the federal government, you have the state, and in addition to that, you have agency. And the agency here, you have a law that is called the Chevron law, which pretty much gives authority to agency to regulate environmental violation. So this is the foundation, the bigger foundation of the the U.S. environmental law and also U.S. Human rights. So when it comes to a human right violation, you also have the amendment that regulates human right violation. But when it comes to environmental violation, you have the Chevron deference, which means basically every or any government branch that is that deal with certain violation of environmental law has the power to deal with that violation. So it's a very complex situation where you have the states, you have the federal government, and also you have the agency that plays different roles based on the that statute I just mentioned, the Chevron deference, which is it's a big case here in U.S. where you have, when there's a violation, environmental violation, any government agency is called upon to intervene and to solve the issue. So I would love if we can maybe continue with that. We can build on that. I'm very open to it to talk about. I've studied U.S. administrative law. I understand. I have a great understanding of the way U.S. agency work when it comes to environmental law. So we can talk about that too. Thank you.
Thank you, Ibu. Answer your questions. Okay. I think Bapak Ibu, that's it for today's first plenary sessions. I'm afraid we cannot have more questions, Doctor, also. And maybe we are going to invite you next time because it's a heavy book. We need like 1 day lecture for this one. So thank you so much. That's the end for the first plenary sessions. But we still have one more session, yeah. Certificate of Appreciations from Professor Tongat. Do you mind also, Doctor? Yes.
Okay, thank you, Ms. Arum, and also Prof. Tony Junaidi Gunawan, and also Prof. Hilary Teknan and Mr. Hasnan Bakhtiar. Yes, could you please come to in front of? Could you please come to in front of the stage? Yeah, we invite Prof. Tongat to give the certificate to Dr. Teng Junaidi Gunawan from Universitas 17 Agustus Surabaya, Indonesia. Thank you very much. Thank you very much. Please give a round of applause one more time for all of the speakers and also Ms. Arum. Great job. Okay, ladies and gentlemen, after this we have 90 minutes for the whole prayer and also lunch break. So please come back at the main room at 1 p.m. here. We will continue to the second plenary session. I hope you can enjoy your lunch, but before that, untuk Bapak Ibu yang tadi sudah bertanya, kami persilakan untuk dapat mengambil bukunya ke depan. Oke, kami persilakan Bapak dan Ibu para penanya boleh maju ke depan sekarang juga. Kita akan berfoto bersama terlebih dahulu bersama Dr. Teng Junaidi. Okay, thank you for asking the question, and this is the book from Dr. Teng Junaidi. Yes, and the last for Ibu. Okay, thank you very much. Please take a group photo together. Okay, thank you very much. Please have the seat. And ladies and gentlemen, we also have digital certificate for Professor Hilary Teknan, and will be shared on the screen. Ta-da! Okay, this is the certificate for Professor Hilary Teknan from Center for Legal and Court Technology, William and Mary Law School, Williamsburg, VA, USA. Thank you for being our invited speaker today, Prof. Hilary Teknan. And the second is this digital certificate for Mr. Hasnan Bakhtiar. Yes, the certificate is for Mr. Hasnan Bakhtiar. Thank you for being our invited speaker today. Terima kasih Bapak dan Ibu. Thank you very much. And that's all the first session. We will continue to the second plenary session at 1 p.m. So please enjoy the lunch and also your break time. Thank you very much. See you again. Sebelumnya kami persilahkan Pak Tongat dan juga seluruh speakers untuk dapat berfoto bersama terlebih dahulu. Please come in front of the stage for all speakers and also the Dean of Law Faculty. We will take a picture together before enjoy the lunch. Silahkan Prof. Okay, ladies and gentlemen, welcome back to Inclar 2024. Already enjoyed the lunch, right? Okay, so let's move to the second plenary session. The next we have Associate Professor Fokke from Maastricht University, Netherlands, Mr. Najih, PhD, the Chief of Ombudsman of the Republic of Indonesia, and also Professor Dr. Jadi Zaidi Hasim from Universitas Kebangsaan Malaysia. And the session will be moderated by Ms. Arum again. So Ms. Arum, time is yours.
Assalamualaikum warahmatullahi wabarakatuh. Bapak Ibu, sudah fresh ini? I'm afraid kekenyangan ya, jadinya a bit sleepy hopefully not. Semoga enggak. So I think we are now ready for the second plenary session while also waiting for others to join back. Maybe some of them still do the Zuhur prayer. So again, I'm here going to be the moderator for the second plenary sessions. And I need to remind you back about the rules. We will still have the same rules as we had in plenary session 1. So each speaker now, besides me, next to me, going to present for about 20 minutes only. And we are also going to have about 30 minutes session for Q&A, yeah? And I'm not really sure about the book. Do we still have the book for the prize? Okay. Bapak Ibu, maybe a bit of bahasa ya. Just in case nanti Bapak Ibu perlu bantuan to translate, that's fine. Boleh nanti mix bahasa Indonesia sedikit nggak apa-apa ya. Lokalnya masih kuat, that's fine ya. Just let me know. But I want you to pay attention. Nanti saya bantu untuk bahasa Inggris kan ya. Okay, let's have the very first speaker for the session plenary session today. Bapak Fokke ya, Professor Fokke here, J. Van Hout. I think he's been visiting UMM for several times, yeah, Prof, right? I just want, no, I met you like the last time, right? So this Professor Fokke J. Van Hout, again, it's hard, yeah, Netherlands name for me to pronounce. It's actually from Maastricht University, Netherlands. His academic interests include the fundamental values underlying legal system and also the applications to the concepts like property and also access to justice. He has published several papers, it's actually not several, but plenty papers on the relationship between law and also morality, and his recent research focuses on legal reforms, to enhance social justice in Europe. So today, Bapak Ibu, he will presenting basic human values as basis for a new type of legal reasoning applied to the concept of property. So please welcome Professor Fouquet.
Thank you very much, Bu, for introducing me. Thank you very much, Professor Tongat, who is not here, for inviting me to this conference. That's a big honor to be here to talk to you about my ideas, because I always have ideas that are a bit different from the ideas from others. So I love to share them with you in the hope that you can give me some feedback and maybe you agree with me. We don't know. So the subject is, and I see myself over there, but I do not see my presentation. Can I have the first slide, please? I just saw the slide. Oh, that's it. I have to introduce myself. I'm from the Netherlands. I'm a retired professor from Maastricht University, although I'm still connected to Maastricht University. I coordinate double degree programs with Indonesian universities, and I coordinate competitions there. At the same time, I'm a lawyer. I'm a pengacara pada Mahkamah Agung di Belanda. So I still work as a lawyer in very nice legal cases. So I'm a real lawyer too, but I love the philosophy of law. Let's see the next slide, because we're asked to rethink humanity values, which means for me to rethink legal values in a time where we can say that there are a lot of problems in the world. Those problems are about wars, they are about the distribution of wealth, which is not according to any standard of equality, and it's also about the problems with the climate. And when we try to find a cause for that, I would say that the cause is mainly, or for a big part, there where the governments are failing and unwilling to do the right things. That's an important remark, since Professor Technow told us all the time what the governments have to do. He said it at least 10 or 15 times, but they don't do it. So we have to look for other concepts, and that's the idea of this conference. We have to rethink legal values, because lawyers can do something, but we can say that at the basis of the problems, we have some legal concepts that maybe could be redefined. No, I was not finished with my slide yet. Could you go back? So the problems we encounter now in the world, they are supported by legal concepts that are based on exclusivity. That means that we can keep away others from, we have no obligation to let them interfere with what we're doing. That is exclusivity. Exclusion, we can keep them away from us. And exhaustion, we can do with the wealth of the world what we want. And I'm talking about property now, of course. So next slide, please. Oh, this is the slide I want, so that was good. So we can now think about what lawyers could do. And the first idea I want to give you is it would already be very good if lawyers just apply the law, because all over the world I see that lawyers do not apply the law. The law in itself is often quite good. Also international law. We have treaties with good ideas, good obligations. Human rights are protected. But when we go to a court or when we ask our lawyers to work with it, they simply do not do it, or do something else. So that would be a nice thing. In the yellow rectangle, you see something that really comes from my heart. The court deviating from positive law with good intentions is just as despicable as the court that bases its decision on the party that pays best, the corrupt court. Legal certainty is a very important value, one of the most important, and we will see that later in this presentation. So we as lawyers, we can do something about it, and what we can do is we can try to rethink those legal concepts that we take for granted, I'm talking about property, you will see that, and give them a firm new basis, a new basis that is based on human values, on humanity, if you want. And maybe that could help us. That could help us in a context where the lawyers apply the law. Let's see how that could work for the concept of private property. And I'm going to take you now on a journey through history. We're going to make a long journey. Can I have the next slide? We start 600, 700 years ago. If we have the next slide, we can go back in time. And we have to wait for it. Traveling in time always takes time. And there we...
Next slide.
Next slide, please. There we go. We are in the 14th century. Because it was in the 14th century, already way after the Romans, etc., when for the first time the concept of private property came up. And it was defined by this guy, Bartolo Sassoferrato. And he was the first one to ask the question, what is that property? What is dominium? What is it to being the boss over an object? And he gave this answer that in fact still determines the way of thinking about private property. His answer is, it is the right to have full possession of a tangible object unless the law prohibits it. That was his definition. It was in Latin, of course, but I translated it for you, so it's easy to follow. There are 4 elements in this definition. The first one is, you have unlimited power. You can do with it what you want. If you own a mine, you can exploit it in any way you want, and you can do nothing if you want. Unlimited power. Regarding tangible objects, we still think about property in that way. It should be about things you can touch. For intellectual property rights, we have special rules. For ownership of claims, for instance, we have special rules. It's about tangible objects. And it's limited by the rights of others and the law. Of course, there is a law. If I own a hammer, I'm not allowed to kill my neighbor here because I maybe don't like him, because I'm the owner of the hammer, because the law prohibits that. So there are limits in the law. And one thing is very important, because that will come back all the time when we go through history, there are no inherent obligations. If you are an owner, Bartolus doesn't tell us that you also have obligations towards others or the society. Maybe you already see the root of the problem. But the interesting thing is that already in old ages, there came some opposition to this idea. So we see through history that there are 2 approaches to private property. There's the approach of the unlimited ownership, and there is the approach of ownership with some kind of obligations. We make big steps. We go to the next one, thank you. I wrote a paper, and that's more subtle than this, but I don't have the time to go through all the philosophers. This is already the 15th century, and there we have Mr. de Soto. He was important in his time. There was a saying, if you know de Soto, you know everything. So he wrote down everything that is important about law. And he said, well, what is ownership? To use things for your own benefit. That's interesting, because he adds something to the, well, he restricts the unlimited power. He says you can be an owner, but you have to use it for your own benefit. Others drew the conclusion from that, okay, if you don't do that, you lose your property. It's in fact a very modern idea. Modern philosophers come up with that idea. If you don't use your property in such a way that you can profit from it, then we are allowed to take it away from you, because then it is useless. Maybe in the form of taxes or in the form of expropriation. It's a very modern idea. But then we see the pendulum, you know the pendulum of history is going back and forth. In the 19th century, thank you, that's the one I wanted. In the 19th century is going the other way again. We have the Industrial Revolution after the French Revolution, where the owners could really do, and we're talking now about the West, what they wanted. Especially in the place that I am from, Maastricht, we had owners of factories, sweatshops, where children under 12 years old, had to work 16 hours a day. And we are not talking about 1100, we are talking about 1880. That's not so long ago. 16 hours a day, children 9, 10, 11 years old. And then the government, in the government, there were people in parliament saying we should restrict that. But then the philosophers, like this French philosopher, he's one of the most famous in that respect, de Molombe said, no, you're not allowed to do that. The government is not allowed to interfere with private property. Whatever he does, the owner, he has the right to do it, because private property is absolute. If we would restrict it, it would not be absolute anymore. So, not allowed, leave him doing what he wants. He can abuse it, he can use it, he can misuse it, but that's property. Of course, there was a counter-reaction. We had the socialist movement. We had a lot of social regulations to help those children, to forbid child's labor. And now we jump to the Second World War. Can we have the next slide? Because gradually the idea took shape that we have to add something to our idea of private property. And that idea, we found it in the German Constitution after World War II. World War II was also part of Paksikic's presentation this morning. Many things changed afterwards. People started to think over and rethink things. And one of those things they were thinking about was private property. So in the German Constitution, private property became a right, you could call it a human right, but at the same time, in the second section, it says, for Article 14, property entails obligations. So there you have it. It's not just you can do what you want with it, you can also have obligations, but why? Its use should also serve the public good. That sounds very nice, but it's the Constitution. You know everything about constitutions. Constitutions are more flexible than you would like them to be, because they too, they have a Mahkamah Konstitutie. And their Mahkamah Konstitutie had to give decisions regarding that social use of property. And in Germany, it's only about taxes. How much taxes are we allowed to ask of the owners of property? And in the end, their constitutional court said, we can tax them for anything we want, but we cannot take away the property. That's the only limit. So you see a nice idea that makes a better concept of private property was changed by the lawyers to become something to justify taxes, and that is all. No, that's the last point there, no horizontal positive obligations. And I think that an idea of property with horizontal between subjects, not between the subject and the government, horizontal obligations as inherent in private property would help us. Okay, let's see. Because after this discussion, we could say something like, do we need property at all? Because we see that private property did a lot of things wrong, and in Indonesia and in the rest of the world is still the shield that is being used by the people who do some very bad things to other people and the environment. So, can we get rid of private property? Here we have another famous philosopher, Herbert Hart, and in his wonderful book, The Concept of Law, and one of the chapters is about property. And no, it's more about natural law in his sense. And then he says something that's very wise. You should remember that the rest of your life. He said, why do we have law? to keep society together. That's why we have law. Without law, a society would fall apart. So, okay, from that we can say, what do we need to keep society together? And then he says things like we have to take into account that people are not angels, but they are also willing to do the right things now and then, and sometimes we have to punish them to make them do what they want, so we need sanctions, we need rules because people are not invulnerable, so we have to protect them against others who want to do harm, and we need rules regarding the scarcity of commodities. We need rules for that, because otherwise one person has everything and the others not, society perishes. So we need some kind of property. So we cannot do without it. Let's see how far we should go then to have property. I want to show you two, next slide please, show you two approaches. This is the approach of the economist, Friedman, famous economist, wonderful book, Law's Order, if you like it. It's right-winged, it's Trump-like reasoning, and what he is saying is, well, this is a stupid question, what should be property? Everything should be property. It's the best way to solve two problems. One, it gives a very good incentive to people to invent things, to make new things of which we all profit. And the other one is, it's a very good way to solve the problem that we cannot drive the same car at the same time. We use private property for that. So for him, everything should be private property without restrictions. So that was the problem we were talking about. So Friedman is not a good idea. We have a completely other approach, also from the 19th century. Let's see, the next slide, please. Here we have the famous Proudhon. He is famous because I am almost sure that nobody read a letter of what he wrote, but you all know his saying, property is theft. Pemilikan adalah pencurian. You steal from others by being an owner. That is Proudhon. So he says property is psychological. We think about property, but in fact it cannot even exist. And since it cannot exist, if you own something, you are a thief, because it's impossible. That's his reasoning. Basically, what he says is that property is a way of justifying doing harms to others, because by accident you are the one who has the dominion, we talked about that, of a certain object. It's a nice way of thinking, it's a wonderful book that he wrote, but in the end you will say, well, it won't help us. So, what do we need? First, I want to talk to you shortly about a case. Next slide, please. It's a famous case in the Netherlands. It's a climate case. If you have, and that's why I believe in thinking from private law instead of public law. Everybody I heard this morning, it's all public law. Here this starts from private law. To make it work, of course, there are some conditions that have to be fulfilled. And the condition that has to be fulfilled is that you have a society with the rule of law and a division of powers, where it works. If that's the case, you can do a lot with private law. So in Indonesia, you have a Mahkamah Konstitusi, but you are never sure what's the outcome, what the outcome will be. If you listen to the Mahkamah Konstitusi in the morning, you get decision 1, and if you listen again 3 hours later, you get a completely opposite decision. That is no rule of law. Since that happened in November here in Indonesia, I completely struck out Indonesia from the list of countries with the rule of law. It doesn't exist here. But if you have a country where it exists a little bit, you can be very powerful. This is a famous case all over the world, because in the court, private citizens started a procedure against the state of the Netherlands, claiming that it should fulfill the norms of the treaty of 1992 regarding greenhouse gases reduction. And that is special. When I talked about it with Indonesians, they said, oh, we have that too, because sometimes we can start a case against the city and then we tell the city to close down something or not to do something. Those are easy cases if they exist in Indonesia. I took it for granted. But this is a difficult one because the government is ordered to do something that they promised to do themselves because they signed a treaty. And they were forced to do it, and the government now has to do it. We had a lot of changes in the Netherlands after that decision of the courts in 3 instances. They all agreed. They have to do it in a positive way. It has to be reduced to 20% or I don't know what in 2030. So that has to be done. Private law with an independent judicature, an independent courts, can order the state just by applying the law to do the right things. So let's go back to private property again. Can I have the next slide, please? And see if we can come up with a new concept that doesn't take the core idea of Bartolus, the first one we talked about, but that's also talking about positive obligations. If you're an owner, you also have positive, horizontal obligations towards others. We apply, when you're talking about it, you have to think about proportionality and subsidiarity. You cannot ask of an owner to give it all away, and you cannot ask of him, of one person specifically, to do something when there are other ways of achieving your goals. So you need those principles. And then you need something that is not arbitrary. And that's the problem. That's the problem when you talk about natural law, redefining humanity. It's your humanity. It's your way of redefining the law. It's your ideas, and somebody else disagrees probably, and then it risks to be arbitrary. But I think there is a solution if we go to a philosopher that is not at all my favorite. He is not at all my favorite. I think many of the things he wrote are wrong, but here he has a very good idea. And we go to Mr. Finnis in the next slide, please, if possible. Because he says, well, we can think about basic goods for anyone's well-being. And the nice thing is, this is rooted in the way people are with all the variety that we have in human beings. Some people have a lot of talents, others don't, but for all of them, even if they're handicapped, etc., these 7 basic goods, they hold. And they are life, life, you want to live, knowledge, play, aesthetic experience, art, friendship, practical reasonableness, that is freedom, that you're allowed to do what you want, and religion. Those are the basic things everybody needs. And I think that this is very good as a basis for a concept of private property in which social obligations based on the basic goods can be integrated. If we apply it, I want to give you an example of the beaches of Rio de Janeiro. Can I have the next slide? So here are the beaches of Rio de Janeiro. What's the problem there? There was no problem because those beaches were, according to the old Roman rules, the property of everybody. Res communis omnium. So nobody could say you can use the beach or you cannot use the beach. It was everybody's property and it was out of the commerce. You could not do anything with it. But now the Brazilian government decided that, and they can do that according to the very old idea of the eminent domain of the state, and all states have that idea. You can have your private property, but if needed, we have an eminent domain and we can do something else with it. From that eminent domain idea, the Brazilian state said, we're going to sell out the beaches to private owners, and they can do what they want. They are going to do that. They will make it private property, and those owners will have the right to exclude the population of Rio de Janeiro from using the beaches, or they have to pay. Well, they have to pay. Well, if you have a new concept of private property based on those 7 basic goods for anyone's well-being, you can say, well, if there are no beaches left, so the population of Rio de Janeiro has no other possibility, that's subsidiarity, then the local people will have the right to use the beaches of the private owners, because that's their well-being. They have a right to play, friendship, and anything else they can do on those beaches that's related to those basic social goods. And they can do it to a reasonable extent. That's a proportionality. So the owners will have to allow the people to use the beaches. That's another concept of private ownership that's not based on exclusivity, on exclusion and exhaustion, but makes it more social. And I think that when you come up with a basis like this, the basis Finis gives us with the 7 basic social goods for anyone's well-being, you have founded it in a way, grounded in a way, have given it a basis that is not arbitrary, but has to be accepted by everyone. Can I have the last slide, please? Because the last slide will tell you that I thank you very much for the opportunity of sharing these thoughts with you, and I thank you very much for listening to me.
Thank you, Prof. Okay, now again, let's continue the discussion. Save your questions. Thank you again, Pak Najih. Next one, as you can see here, beside me, next to me, we have our second speaker is Dr. M. Najih, the Chief of the Ombudsman of the Republic of Indonesia. So if you're interested on such field, yes, please get ready. Yeah, he oversees also the protections of personal data within the context of public services, especially in disruptions era marked by technological advancement. Today, Dr. Najih going to discuss the personal data protections in the context of legal enforcement and human rights for citizens in the disruptions era regarding mismanagement in public services. I think you're ready, yeah, Doctor. Okay.
Thank you, Moderator. Thank you to my Dean, Faculty of Law, Muhammadiyah University of Malang, Professor Tongat, and committee for inviting me to be a speaker in this conference. I also convey and apologize from the chairman of the Ombudsman of Kingdom of Morocco, Mr. Muhammad Bonalulu, who was supposed to be present in our conference, but at the same time, as a sudden event from the Morocco Parliament and King of Morocco. I respect as distinguished the speaker, Dr. Fouke and Dr. Jadi. And all conference participants. In this time, I will try to convey topic about personal data protection, legal enforcement, and human rights in the disruption era, especially about mismanagement in public services. This issue is very important considering that in the Indonesian context, since the passing of the personal data protection law, law number 27 of 2022, there have been safe that personal data with professionally within the scope of civil law has become within of public law. The correlation, the correlation between the rule of law and human right and inseparable, much like two sides of the same coin. The law play of a crucial role in safeguarding and ensuring that each individual gets the full spectrum of human rights through complying regulation, guidelines and rule. Public representative and government and parliament work to protect citizens from unfair treatment, discrimination, delays, failure to receive proper services, fighting legal violation, unlawful acts, and abuse of power by public officials. This action, commonly termed as maladministration or mismanagement, are topically associated with the public administration system. If such action occur within public services, it adoptedly contradicts that the Constitution, our Constitution, 1945, our fundamental law. The Constitution specifically states that human rights must be upheld by the state. Citizens have rights to demand that the government fulfill this right in order to contribute to the nation development. As a result, law enforcement and human rights protection are inextricably likened, serving not only to ensure societal security, order and prosperity, but also to protect individual life, dignity and freedom of expression. In according with the mission of our Constitution, particularly in delivering public services, the government enacted Law 25 of 2009 of public services. This is a service sector include education, health, transportation, information technology, banking, insurance, and communication. This domain are under the jurisdiction and obligation of many ministers and state agencies charged with the delivering, supervising, and resolving conflict of public compliance in the event maladministration by relevant public officials. As a result, there is need for compliant handling process overseen by the Inspector General and independent external supervision institution. And when the relevant agency internal compliance unit is enabled to address a public complaint, this independent monitoring body take action. Consequently, they established the Ombudsman of Republik Indonesia as an independent institution for monitoring public services through Law number 37 of 2008. The Ombudsman joined other state agencies such as the National Human Rights Commission, the National Commission of Violent Agent Women, and the Commission for Child Protection, and work together to ensure that human rights are implemented in accordance with the Constitution of 1945. Next. Data protection and recognized as a fundamental human right in several countries. Some have enshrined
data protection as a constitutional right or in the form of habeas data, which ensure individual right to ensure their data and seeks readers from any incuration. Moreover, applying digital technology raises cybersecurity concerns such as data breaches, ransomware attacks, and other unwanted activity. Many regions and industries have enacted strong data protection legislation, such as the Digital Personal Data Protection, the General Data Protection Regulation in Europe, and the California Consumer Privacy Act in the United States. Countries such as Albania, Armenia, the Philippines, Timor-Leste, Colombia, and Argentina, is with unique histories and culture, have acknowledged the role of data protection in supporting democratic processes and have guaranteed its protection in their respective constitution. However, in Indonesia, there have been recent public complaints regarding personal data protection as a result of the rapid development of information technology and internet, which expose personal data to misuse. In recent years, this problem has grown in tandem with increasing number of electronic transactions and personal data misused by companies, institutions, and often government. According to the Compass, in 2022, there was data leaks involving 1.3 million use Ministry of Health a hack program. Red Forum sold BPJS Health, which cover 279 million people. They successfully hacked and sell 4,063,000 documents from BRI, Bank Republik Indonesia, customer for $7,000 and 2 billion, and in same time 15 billion Tokopedia user data traded in online forum. This issue raised earlier pertain not just law enforcement but also the government capacity and servicing public as outlined in Article 5, Paragraph 2 of Law Number 25 of 2009 concerning Public Services Law. According to the law, public services encompass various sectors, including communication and information, particularly concerning the misuse of unauthorized use of personal data. Additionally, the vulnerability of the cybersecurity system poses a significant challenge to public services. In a recent 2024 incident in Indonesia became victim to digital attacks involving the hacking state data, resulting in the incapacitation of the National Data Center (PDN) server due to a Lockbit 3.0 ransomware attacks in 2024. Based on article from Vantim Press Office, there are 210 government institutions leading to disruption in digital public services and potential for maladministration, such as service delay, failure for provide services, abuse of authority, and procedural irregulation. Sysrex provided data indicating various incidents in the hacker demand or ransom of until $8 billion or 135 billion to release Pusat Data Nasional. This incident underscore significant cybersecurity challenger in Indonesia as the country data protection was compromised by the cyber attacks. At the same time, the government is prepared to restructure public services. Government is one of three types of transformation that will propel Indonesian forward to 2045. The government must use information technology in public services in order to reach world-class status. This name is dynamic governance. However, the envisioned digital-based transformation of public services may face significant challenges if cyber system resilience is not strengthened. According to Google Temasek bin Economy C 2023 report, for now Indonesian cyber resilient position is lagging behind neighboring countries such as Singapore and Malaysia in terms of personal data protection. Personal data protection is governed by law now, number 27 of 2022, known as the Personal Data Protection Law, or PDP. Individuals who own personal data have the right under Article 5 of the PDB law. They get information about the clarity of their identity, the legal basis for processing the data, the purpose of the data request and use, and the accountability of the party requesting the data. According to Article 9, if now an authorized parties use personal data for purposes other than initially intended, the individual who own the personal data can window the processing of their data, even and their data is held by the data controller. Additionally, Article 11 stipulates that the individual who own that data has the rights to the law suite and receive compensation for any personal data processing, the contravening the agreement and consent of the data owner. Even though the PDB law gives legal protection to data owner to ensure that their personal data is neither misused or exchanged, various issues arise when dealing with data leaks. One, Indonesian cybersecurity remains relatively weak. Personal data protection PDP regulation have not been overreached optimally. Three, the complexities of personal data protection problem occur multiple sectors. Four, there has been no widespread and systemic outreach and education from authorized institutions regarding the importance of protection personal data from the public. Five, there is not standardized early warning system for all authorities to out and educate the public. These are issues received by the Ombudsman, both from a public complaint and public service consultation related to personal data protection. The most recent was in 2023 with the PT Telkom Kota Jambi and the Communication and Information Office of South Kalimantan as the respondent, and so on. In resolving public complaint, the Ombudsman performed duties and function as regulated in Article 8 of Law Number 37 of 2008 on the Indonesian Ombudsman. The Ombudsman has the authority to conduct an investigation of alleged maladministration. If maladministration practices are discovered, the inquiry result will be used to recommend corrective step for the respondent. If the respondent failed to take corrective measures, the Ombudsman will issue a recommendation that must follow it. If our recommendations are still not implemented, the Ombudsman has the ability to publish the respondent maladministrative practices in various media channels and to write to the respondent to supervisor. This demonstrated that sanction for violation of personal data ownership rights and based on only Law Number 27 of 2022 on personal data protection, which imposes administrative sanction, but also in Law Number 37 of 2008 on the Ombudsman and Law Number 25 of 2009 of public services. And conclusion is my presentation. Law enforcement, the rapid technological advancement in Indonesia have led to various new legal challenges, particularly in privacy and cybersecurity issues. Indonesian legal system is currently under prepared to confront the issues which may restrict innovation and jeopardize Indonesian resident digital rights. To resolve the problem, an interdisciplinary approach is essential, combining legal expertise with the thorough understanding of information technology. One key area of improvement is the development of places and innovative solutions to protect Indonesian citizen digital rights. And public services, to ensure that the digital public services government stays adaptable to cyber state, the government must build a cybersecurity system based on a number of crucial components. For example, one, using data-driven risk analysis based on big data and predictive analysis. Two, identifying change for innovation through new technology and collaborative partnership. Three, conducting systemic risk assessment using regular security audit of identify vulnerability and services system. And four, developing a rapid response strategy for one online dangerous training program and exercises. Thank you for your attention.
Thank you so much. I think this is also like the newest case here, Doctor, yeah, happening in Indonesia last June. We have like 160 NGO or government institutions being hacked. So we got data breaches very significantly happen. So mungkin nanti yang tahu infonya yang kebobolan data tuh ada yang kena, nanti boleh ask questions juga ya. Okay, so the last but not the least, we got a big smile from Professor Dr. Jadi Zaidi Hashim from Universitas Kebangsaan Malaysia. Professor Hashim's work examines how law can govern and support regional development, addressing challenges posed by the pandemic. He has authored several books also on legal development and governance, and his research often intersects with public policy and economic development. So today, Professor Dr. Jadi going to present Building Legal Resilience for Sarawak. For the detailed information will be given. Yes, please, professors.
Thank you very much, Ms. Moderator. Okay. Benar, penantian itu satu penyiksaan. Because I'm the last presenter for today's sessions. Then try to make sure that everything's counted and try to make it precise as possible, since we are.
I'm sorry, Professor. Maybe it sounds a bit impolite. Can you please make the microphone closer? Because probably the participant back there cannot hear your voice.
Am I audible now? All right, good. All right. Okay, once again, I would like to say thank you very much, for inviting me here today. All right. So obviously, it's not my fault. Thank you. Now much better. Okay, once again, I would like to say thank you very much, Ms. Moderator, for introducing me. All right, thank you very much. My learned panels today, Prof. Fokker, as well as Dr. Najee, who I believe that, interestingly, discussing many points of interest, especially with regards to the property, ownerships of property, probably the possessions of the property, and then of course, when we talk about Dr. Najee's presentation just now, we discussed about ombudsman's rights, etc., etc. And then, as for me today, I'm doing something, probably presenting something different. One of the case study with regard to one particular wilayah regions, we call it, but within Malaysia, which is called Sarawak. I believe, probably some of you had visited Sarawak. Of course, most of you probably visited Malaysia for holiday probably, or for conference. But when we talk about Sarawak, probably Sarawak is one of the country or entities in Malaysia, forming a part of Malaysia since 1963. But then the name is not so popular. Probably. That's what I'm thinking. But yet, at the same time, offering something that probably we never thought of in terms of preparing themselves, preparing the country, preparing Sarawak itself, with regard to our topics of discussion today, which is disruptions era. How many of you still remember when was the last dates? When is the first day of COVID-19? Anybody still remember what is the first day of COVID-19? When it was occurred previously in 2020? Exactly, March 2020.
No, 13 March in the Netherlands.
Yeah, probably that's around that dates. It seems like almost 4 years, 4 years and 4 months, more than 1,500 days after the COVID. What is the preparations? We are talking about a lot of things, I believe, which is good for the country, but how effective the law that we try to apply to protect people in order to accommodate this disruptions era. Now we are talking about a lot of things, I know. guidelines, everything, but to what extent, okay, the country is prepared, moving forwards to ensure that everything's inclusivity of the people being counted. That's the point. Thus, okay, today, I just simply take one small example of Sarawak, how Sarawak, this part of Malaysian state, we call it, try to facilitate, try to accommodate, okay, the people on how to run the administrations, right? We know that, okay, similarly in Indonesia, okay, we have federal government, central government, as well as states governments. They do have what we call the concept of federalism. Not yet. Okay, just go back. Okay, this is Sarawak. Probably, okay, this is good. Okay, to show. They do have, okay, what we call, okay, the concept of federalism, the sharings of autonomous power. When we talk about, okay, for focus just now, the ownerships, it comes, okay, together with the concept of ownership as the concept of autonomy. But how much, okay, the control of autonomy is being adhered to one particular state in order to administer, to control its own activities for the people? That's the problem. We are talking, okay, too much probably, too big probably, okay, but then, okay, when we talk about implementations of the law itself, then, okay, probably it's a failure. That's why when we talk about Sarawak here, this is the location of Sarawak. I don't have, okay, pointers here, but I think, okay, everyone can imagine where the Sarawak is. But, okay, the point here is, okay, how to build legal resilience for Sarawak. Sarawak came up with the policy, specific policy for try to accommodate the issues of COVID-19. They call it, okay, post-COVID-19 development strategy. Not very thick policy book, but full of informations. My part, of course, I can try to elaborate more, deliberate more, how law actually, if not in the world, probably in Malaysia or Sarawak itself, okay, to come up with, okay, agendas, how that least law, for example, okay, able to govern the contents of this policy. Otherwise, okay, this policy just left behind as a documents, as a paper. People may refer to it, but there's no what we call legal enforcement, execution, or legal execution of this policy. Then, okay, at the end of the day, 2030, it's become nothing. It's just left as a documents. So then, okay, this is the points, okay, that I want to share with all of you. Probably, okay, Indonesia, I believe, okay, come up with good policy. At other worlds, okay, other countries in the world probably can also come up with the policies, but I'm referring to one particular state in one country, Malaysia, that applying their own policy and try to safeguard the people through the implementations of the law and policy. That's what I'm going to elaborate. Of course, okay, I don't have much time. I'm going to skip many slides as we promised just now, actually. But then again, in fact, it's more than 20 minutes. Mine is only 10 minutes or probably 5 minutes. All right. Talks about legal resilience. This is what we call 101's basic understanding. What is legal resilience? But most importantly, okay, the words adapts here. The law that we try to come up, create, must able to adapt with what? Challenges, changes, pressures. This is what actually happened during the COVID-19. People are, wow, shouting everywhere, asking for helps. Then, okay, law comes later, which is, no, at the end of the day, okay, try to protect and safeguard the people. But then, okay, slowly people try to adapt themselves, government try to adapt themselves, try to come up with the policy, with the law that able to adapt that particular challenges. See? And this legal resilience must also include certain aspects. Otherwise, okay, we cannot say it resilience. Otherwise, okay, it's legal frameworks. Frameworks is nothing. It must have certain identities, certain characteristics to make it resilience, to make it able to safeguard the people, safeguard the country. So, legal resilience here can include aspects such as robustness, adaptability of legal institution. That's why I believe that, okay, part of law probably not only enforcing the law, the executions of the law itself, it must able to institutionalize things. By having the institution, then, okay, then okay, it follows with the execution. This entity, this institution, based on enables provisions given to it, able to protect, able to safeguard the rights, whatever thing that okay, been discussed today, since this morning, including okay, the issue of possessions, private rights, and then okay, intellectual properties. Because okay, I believe in this policy later on, if we have enough time, we can see that okay, the power of this policy actually sanctions or backed by data and innovations. So we cannot deny okay, the power of technologies now. The technology comes with it, data. Okay, with data we have powers. With powers, okay, we're able to have autonomy to control and to decide. Anyway, it ensures legal frameworks remain stable, reliable, and functional even during turbulent times such as COVID-19. All right, next. Okay, this is the key components. I cannot create the QR codes. Otherwise, I can share with all of you. Probably okay, later on, the committee, the organizers will share my slide to others. At least, okay, you know the contents of this post-COVID-19. Anyway, this is just a key components of legal resilience. I'm not going to read all these components, but there are more than okay, these 6 elements being showed here. Probably okay, more than 10 or 15. If you, for example, Google it, okay, you can get more points, okay, what is the characteristic of legal resilience. But most importantly, it must have the character of adaptability, justice and fair. Rule of law, due process must be there. Adherent to international standard. Remember that okay, there are many things that okay, done by the states, by the federal government, for example, within their own shoes without considering international elements. In order to compete or in order to make it sustain okay, for the future of time, of course, it must be adherence to the international standards as well. And then, okay, now is 2024, next year 2025. The strategy, actually, the post-COVID-19 strategy development for Sarawak, okay, ended 2030. Meaning to say, okay, we are halfway, first phase of the policy. But the planning must be since probably 2020, or probably okay, now in the midst of the planning, and then okay, the planning must be continuous up to 2030. It must be, I think, okay, resembles with 2030 SDGs. Of course, based on my reading, almost 60% of the element of SDGs goal already being achieved through this policy. All right, but then of course, okay, we know that SDGs okay, contains of many things. All the 17 elements, okay, there are many things being discussed of. Anyway, next. Okay, this is the facts about Sarawak. Very brief, containing roughly the population's demographics around 2.4 millions. Small states in Malaysia compared to the whole Malaysia. Okay, compared to Selangor, those who has been in Selangor, visiting UKM in Malaysia, of course, okay, you must be Selangor first. Dato' Ajih, also, okay, no, how many years in Selangor? More than 10 years? 5 years? More than 10 years in Selangor. Then, okay, probably he knows, okay, many things about Selangor. But here, of course, small states in Malaysia, only 2.47. This is the demographics facts of Sarawak. I don't want to explain further. Okay, just go next. But this is the aspirations. Of course, this aspiration is not sanctioned yet by the policy, by the law, by the legal framework. It is just an aspiration by the Premier, the Chief Minister of Sarawak. Intention, what is the directions of Sarawak for 2030? You can see that okay, the aspiration by 2030, Sarawak will be a thriving society driven by 2 things. The first one, data. The second one, innovation. We will discuss okay, after this, probably okay, just go slide by slide. Simple. What are those innovations that prepared and considered by the Sarawak governments? Where everybody, and this is the end result of it, enjoy, number 1, economic prosperity. We're talking about GSD and everything. Social inclusivity, everybody included, the old, the young people, everyone's, as well as when we talk about environment, or when we talk about sustainable environment, of course, this element must be included to ensure that the state sustains everything, in terms of the economic, digital economy, in terms of environment, etc., etc. All right. This is what we call the final, or the findings, the aims of this 2030 policy. Next. Roughly, okay, my presentation is on this slide. Okay, there are 6 key economic sections that have been discussed in this policy, and 7 enablers. We talk about enablers, okay, the one that boosts or try to make sure that all these 6 economic sectors are being performed. But bear in your minds again why I'm choosing this topic today. When we talk about legal framework, when we talk about executions of the law, or in the eyes or perspective of law, there's none. It is more on the economic perspective. It is more on other enablers, enabling sectors that boosting these economic sectors. After this, we can go one by one, all these 6 economic sectors. But of course, we are not going into detail. And of course, how the 7 enablers can be sanctioned, can be supported by law. Because the topic for today is how law able to govern this post-COVID SDG. Post-COVID strategic developments 2030. Or just make it simple, Sarawak 2030. Sarawak 2030. Can we go to the next slide? Okay, the first economic factors, of course, manufacturing. It seems that manufacturing is one of the important key economic factors in Sarawak. Why, and what is the strategies by them? You can see they are now talks about exports, everything, including try to diversify the products of the state. Try to make it as precise as possible, moderator. Next. The second economic factors, you can see, beside manufacturers, they are talking about agriculture. You are talking about, of course, technologies, but they are talking about agriculture. Recently in Sarawak, there are awarding the agencies, more than 100,000 acres of cultivating paddies only. They want to have their own agriculture. What are the strategies? You can see all the strategies, including what we call large scales agriculture and food manufacture. We are talking about upgrading supply chains of infrastructure. We are talking about partnerships and access to international relationships. We also talk about sustainability issues. Next. The third economic factors, tourism. Of course, traveling to Sarawak becomes more easier, probably easier than traveling to Malaysia, Kuala Lumpur. And then when we talk about Sarawak tourism, we are talking about products, we're talking about assets that can come up with the brands, Sarawak brands, and then the particular brands can be marketed internationally. All right. That's one of the industry sectors that being aimed by the Sarawak government. Next, economic factors number 4 is forestry. You know that 60% of Sarawak states populated by forests. So we need to say this forestry able to give more monies, financial support to Sarawak governments. Besides that, you can see the strategies given by the Sarawak by developing new revenue streams. Exports earnings, contribution of forestry to tourism through conservation and sustainability management. All these strategies, of course, just to boost the industry or economic factors number 4. Next. Mining. Recently, Sarawak government found one big chunks of, I don't know how to call these kinds of mines, minerals, but it costs more than $1 trillion. It's very big amount. If they concentrate on that particular mining industry only, with all the technologies from German, for example, then I believe that that will contribute a lot of financial supports for the Sarawak governments. Right, next. Social services. This is on something very simple, but then believe it or not, we need to take care, or Sarawak government need to take care all levels of people, the young people, the eldest peoples, the needs for social inclusivity. Okay, all these 6 sectors or 6 economic factors contributes a lot to Sarawak government, but none of the sectors being defined clearly or supported by the legal framework. See, now we talk about the draftings of the policy, COVID Sarawak 2030, since 2022, now it's 2024, going to 2025, almost 3 years, but none of the legal frameworks are dedicated specifically on supporting this policy. But anyway, beside these economic factors, they're still relying on other enablers. There are 7 enablers to ensure that all these 6 economic factors can be achieved. Okay, can we go next slide? This is okay. All right. I suppose I suppose need to explain this one first before talks about the enablers. When we talk about enablers, of course, the enablers that we are going to discuss in the Sarawak 2030 is more on other enablers. It's not legal framework enablers, but to ensure the economic factors can be boosted out through legal framework, we need to consider as well the legal enablers. That's why we believe that enablers can directly define and govern the economic factors, including its designs, management, operation, and relationship with stakeholders and other systems. Meaning to say, if there's further research can be done in the future, I'm talking about in the future, probably now, what is the legal framework, what is the law that able to govern these economic factors, these 6 economic factors? If we do have this kind of legal framework, and it all, besides law, there are 7 others enablers can be easily done. Meaning to say, probably the law complements the other enablers, or it stands by itself, supporting, just supporting or complements in such a way the other enablers. Or otherwise, law can be considered as the one that able to safeguard the enablers. Can we go next slide? Okay, this is the first enablers according to the Sarawak 2030, the digital transformation. They are focusing on digital transformation. Of course, when we talk about digital transformation, there are many laws, legal framework that we can create it or amend it, according to this era, because after COVID-19, we need to adjust. There are many things that need to be protected nowadays. But this is how law able to govern digital transformations. But none of the one that listed here, 1, 2, 3, up to 6 here, being defined by the Sarawak governments. So then, I think the university, for example, the UKM or other universities in Malaysia must take up all these points to ensure that the basis of digital transformation for Sarawak, in order to ensure that all these economic factors can be achieved through the implementation of this kind of law, including the way how we protect personal data as discussed by Dr. Najih just now. But then we need to strengthen more in terms of the more resilient regulations, or the cyber security, etc., etc. With these titans of the law, then the digital transformations enablers can be more stringent, can be more powerful in order to achieve these economic factors. Next, innovation. Remember that in order to achieve the inclusivity, the 3 points just now, we are talking about innovation, data and innovation. But these innovations come with its many other things. And law must be there in order to protect the innovations. We know that there must be law. There must be law that able to protect any new innovation. But for this purpose of enabling all 7 factors, there must be a new law or more strict law that able to protect the innovations. This is all the points, okay, that can be taken up by researchers to ensure that the innovations creations by the Sarawak peoples can be protected. Next. Basic infrastructure. Basic infrastructure means anything that able to link one point to another point. For example, okay, of course, okay, one of the basic infrastructure is transport, but transport, okay, is being defined under different segments. But then, okay, we talk about probably land use regulation. Just now, okay, we talk about possessions, the autonomous power of someone or owners, for example, okay, to enjoy, to exclusively use the possession, the ownerships. But then, okay, with the combinations of the infrastructures vested by the Sarawak government, this ownership become more, give more benefit to that owner. So then, okay, in terms of urbans, developments, SDGs, we talk about, okay, international standards, okay, that back up, okay, the infrastructure, all must be considered as part of the new research to ensure basic infrastructure can be can help, okay, can be considered as enablers or positive enablers for the benefit of economic sectors. Next, this is number 3, transport. Recently, okay, UKM has been awarded by the Sarawak government to come up to discuss about transports only. They are given, okay, 2 million ringgit Malaysia. I do not know how to count it. Okay, roughly 2 million ringgit Malaysia. Okay, just to come up with one new agency, authority, Sarawak Transport Authority, for example. But of course, okay, the first thing that, okay, they need to be considered in their research is what is the power of the federal government, because federal governments control transport. States not controls the transports. But then, okay, to what extent, okay, the autonomous authority is given to the Sarawak state, so then they're able to control their own transport. By having, okay, by controlling, okay, their own transport, then many other things, okay, in terms of efficiency of the transport can be done internally or by the state itself. See? But, okay, the progress of the project still going on. They're still not yet, okay, finding. They're still, okay, proposing, okay, how federal government can probably, okay, delegates the power. We call it devolutions instead of sharing, because there are many terms, okay, being used for federalism, including, okay, collaborative federalism, hybrid federalism, etc., etc. But in this particular term, probably, okay, devolutions, because they can delegate, okay, the power, the federal power, to the state to ensure that, okay, the Sarawak transport can be done by the Sarawak state itself. All right. This is the example. But then, okay, of course, there are many other things that can be showed here, can be further research to ensure that, okay, Sarawak transport can contribute or can be considered as enablers for economic sectors. Next. Utility, mapping utilities, okay, underground utilities, meterings, everything is one of the important aspects. We are talking about utility services, okay, available to all household, such as subsidies and tiered pricing structures. There are many other legal things that, okay, we can do to ensure that utilities can be not only an enablers, but sanctioned or backed up by the law. Next. And then, of course, when we talk about renewable energies, it is very hot. Okay, we're talking about carbon captures in Sarawak. They come up with their own law. Even, okay, the federal government still not have law with regard to carbon captures. But Sarawak government, okay, they create their own law just for the purpose of to empower these renewable energies. So this is one example, okay, how Sarawak government, okay, playing their parts. Because they try to define, is there any the words commercial or energy in the federal list, but there's none. Since there's none, okay, they come up with the strategies on how to come up with their own law, authorize, okay, the Sarawak state itself to run and to control, give license to the carbon captures companies, for example, in order to operate these renewable energies. And that's one of the strategy. But the strategy so far, okay, very good. well been defined, but this is only one aspect. I mean to say, okay, when we talk about other enablers, there are more other aspects that needs further research. All right? Next, education and human capital development. Despite of the importance of educations, human capital development, yet there's no specific law, actually legal framework, okay, that able to support these enablers. Because at the same reasons, education, human capital development still under the power of federal governments. Then how then, okay, they try to get, okay, this power back to the states is different story. It needs, okay, further research. Not yet. I think, okay, that's all. Next. Okay, conclusion. So we believe that by having a comprehensive legal frameworks, of course, that begins with the policies such as, okay, post-COVID-19 development strategy 2030 by Sarawak, or legislation or regulations, it able to define, not only define, interprets, but most importantly, regulates, governs the economic factors. Then it gives more benefit to the Sarawak government in order to ensure that all these three aspects that, okay, aspirations by the Sarawak government just now can be achieved. So then, okay, with this particular slide, after this, okay, probably some of you probably want, the organizers, okay, may want to share it with all of you. Okay, many research in terms of legal frameworks on these all 7 enablers can be further done by all researchers, not only from Malaysia, but I believe from Indonesia, from other countries, because, for example, renewables, okay, energies, when we talk about in Canada, they also come up, okay, with advanced technologies, okay, how to come up with these energies, greens energy, etc., etc. So then, okay, it will give benefit, okay, not only to Malaysia, but I believe will give, okay, double benefit to Sarawak, because it will not only safeguards the Sarawak people, but at least, okay, the intentions of the Sarawak government to make sure that, okay, they achieve something, aiming something in the year of 2030 because of this COVID-19 can be achieved. That's probably, okay, humbles directions, humbles intentions of the Premier of Sarawak. Of course, then, okay, all Sarawakian, okay, must help, must do in the future. I think that's all. Thank you very much. That's the observations of the slide. Thank you very much.
Thank you. Give a big round of applause for the 3 speakers. Bapak Ibu, if I may highlight back again, first we have Professor Volker focusing on the development also fundamental values underlying legal system of private property. And then the next one, we also have Dr. Najee talking about data protections, as the part of fundamental human rights. And the last one, we have the key strategies that is proposed after the post-COVID. So, this is the sessions that you've been waiting for, the Q&A session. Boleh, as I mentioned, bahasa Indonesia dulu, boleh, nanti saya bantu ya. Okay, hold on Pak Ben. Let me give the chance to Ibu. Yes, please. Okay, Ibu, tell me your name first, and also institution.
Good afternoon, everyone. I'm Adisha Mega Christia from Muria Kudus University. My question is for Dr. Fokke Fernhout. Professor, actually, watching your slide about the beaches of Rio de Janeiro, actually, it also happens in Indonesia as 200 islands in North Maluku were sold. For as long as I know and I realize, this is could create some chances for the misuse of rights by the owners, for example, making the island only for their personal profits. Although there is law for it already, but I don't think it will be enforced correctly. My questions, what's the worst thing that gonna happen in Indonesia if this bad thing keeps repeating, and what could enforce the government to do their good political will to regulate property rights wisely? Thank you.
Thank you. I think that's pretty clear, right, Professor? Did you get all 2 questions?
I hope so. That I got everything. Thank you very much for the question. As I understood, it's about the 200 islands there where the people are struggling to maintain their resources, because I suppose that the background of the question is the omnibus law. I've studied that a little bit, and what is happening is that there are permissions given out to private companies in such a way that the local people will lose their fisheries and other resources. So that's exactly the worst thing that can happen, is that the property goes from the people from the islands to big international companies who will use the resources for their own benefits and maybe leaving a little bit for the local population. From an article I worked on with a lecturer from the Tarakan University, I understood that it's quite a struggle to be sure that the local population will keep their rights. And there are three categories of local population, and the real indigenous people, they are in the worst position of all. So I don't know enough about the whole situation, but when I transfer it to the more philosophical approach, the omnibus law and most legislation in the West too, they still have this idea of exclusive and exclusionary and exhaustive private property without social obligations. So replacing that by a more social notion of private property would help a lot, because then the companies could be forced to share their property in such a way that the local population will benefit from it as it did before. Is that an answer to the question, I hope? Thank you.
Ibu? Yes, thank you. So next questions. It's still Pak Ben. I'm trying to not look at Pak Ben. Others? Tunggu dulu, sabar dulu. Come on nih yang muda-muda. Ibu lagi, tunggu dulu. Sama, masih sama nih wajahnya. Others? Come on. Yes, new face. Tunggu ya. Yes, Bapak, please stand up.
Thank you very much. My question is for Dr. Naji from Ombudsman. The issue of data leakage in Indonesia actually is often occur, but we know after that the data just goes away. We don't know the data, what do they do with our data actually. And as you mentioned last time in your slide, that the Ombudsman established the independent institution for monitoring public services through law number 37 of 2008. So my question is, to what extent is the government responsible for ensuring the data protection according to the principle outlined by the Ombudsman? Is the responsibility limited to issuing only maybe warning, or is it including more comprehensive actions and enforcement measures? Maybe that's all. Thank you.
Thank you. Thank you, Bapak. Yeah, it's about whether the ombudsman able to take further action, yeah, rather
Yes,
than just warning, yeah.
Yes. Is it
Okay.
only warning or another responsibility? Maybe more comprehensive or enforcement measures?
Okay. Okay. Maybe about the further impact, Dr. Naji. If it is only warning or suggestions, will that be really helpful for the condition?
Okay, thank you for your attention and your question. About the responsibility ombudsman and the protection data, ombudsman based on public complaint handling first, and then in the Act of 27 Act Ombudsman protection data, Ombudsman haven't no. Yes, Ombudsman have not authority about this issues, but because in this law our government have a new institution about who to protect about this individual protection atau personal data. Maybe like Komisi Informasi or Commission of Protection Data, and Ombudsman only give suggestion for government to make this institution quickly, and then if some people go to ombudsman to complaint handling, we have authority to calling like a Ministry of Information, like a ministry, other ministry, to solve this problem before our people go to court, I think.
That's it. That ombudsman is actually the function, yeah, Dr. Naji, is to oversee rather than taking actions, yeah, or creating a policy. Is that answer your questions? Yes. Okay. Next questions for our neighbor country, Professor Jadi. It's about Sarawak. We have Sengkaling, right? That's a different one. So, adakah pertanyaan? Probably you have any proposal for Indonesia after COVID? No, still? Okay, maybe after this, yeah, the professors. Next one, I think Pak Ben, you resigned previously. Okay.
Yes, I would like to address my question to Professor Foka because I was intrigued with your presentations concerning the new property rights. If I'm not mistaken, the root of the private property and right and the human rights completely different. For instance, like if it is a human right, then it will be an inclusive rights, whereas in the property rights, it's exclusive one, and it's transferable and non-transferable. So if you propose the new perspective of the property rights, then it will change everything, because you know the well-being of the persons cannot be transferable, and it should be a human rights rather than property rights. What do you say about that? Thank you.
Thank you very much, Pap, for the question. So first of all, you suppose that when we are talking about human rights and property, it's an inclusive right. Well, property as a right is not part of the UN convention. It's not there. We have it in the European Convention in the first protocol, Article 1, but that's the traditional property right. So when we talk and think about property, in the context even of human rights, it's just a traditional property right. The idea is that when taking it from a slightly other perspective, in such a way, if we take the American way of talking about rights, that there is a bundle of rights connected to property, and that was what you were referring to. Because in the bundle of rights there is transferability normally when it comes to property. Normally because I cannot sell my lungs, for instance, so they are not transferable, but still we can maybe talk about property. So in that approach, transferability is one of the sticks in the bundle of rights. And what I propose is to add some more sticks, because in the American approach, the fact that you don't have to do something is that some sticks are missing. And the purport, the idea of thinking in another way of property right is saying, well, if property is a bundle of rights, then we have to add more, some more sticks. A few more, and they include obligations towards others. So adding sticks does not have any consequences for transferability or other parts of the bundle of rights. So in that sense, I hope it answers your question. I would say, no, it's no problem. You add to the bundle of rights some sticks, and those sticks are about social obligation. By the way, it's a very old idea that also popped up in very old case law of the American Supreme Court regarding beaches, etc. So the idea that you have some obligations when you have specific kinds of property is not that new. But it could help us rethinking the law in an age of disruption, and that was the idea behind the presentation. Thank you.
Thank you. Probably next question, okay? Woman? Yes. Ibu, let me call upon you back again. Do you still have any questions? Yes. Oh, we got two now. Let's have Ibu with the pink veil first, and then, oh, okay, I'm sorry, the microphone. Okay. Okay. Yes, please, okay, that's fine.
Okay, thank you. I'm a student from China, so now I study at Malaysia. So my question is to the Professor Jedi. Yeah, I think your research is very useful. So just now you talk about the government can do something to hold the COVID-19. So as to the China, yeah, because I come from China, so do you have any recommend that for Chinese government, what they can do? Because you know that there are many Chinese people there, so I think maybe it would be more difficulty for Chinese government to do that. Thank you.
Questions? Thank you very much for the questions. Okay. Just now, okay, if you can remember, we come up with the demographic slide first, just to show, okay, how big the population is, what is the strengths of the populations, what is the strengths of the states in order to carry out, okay, the plans and their policy. I believe, okay, big countries such as China, they come up with more and more comprehensive policies. It's not policy, but policies to ensure that the social inclusivity, the government's structure, institutionals, and legal frameworks can be in order. What are the recommendations? Okay, there are many recommendations. As you can see, all the enablers provisions on the second part of the slide just now. Okay, all these provisions or all these recommendations actually can be taken up one by one, or just check, okay, what are the points related to the enablers that, okay, you are thinking, or in the future, what research that, okay, you want to do. Then, okay, you can elaborate it more and try to suit it with the recommended countries. Because there's no specific what we call guidelines that I can suggest to you. Only you and your government, okay, must sit down and discuss, deliberate together to ensure that whatever come what, as a matter of recommendation, will give benefits to your peoples. Thank you for your question. I think that's all.
Okay,
right.
Thank you.
Yeah.
Different house, different problem, yeah. So, thank you. Maybe the last one. Okay. One table, one person, yeah, Ibu. Okay, then. This is the last question.
Thank you. My question to Mr. JD, as your presentation about strengthen IP law to protect innovation in renewable energy technology and encourage investment in research and development, right? Okay. One question is about what measure the Malaysia government is taking to context the intellectual property law can be strengthened to protect and encourage innovation in the field renewable energy, with will ultimate help the achieving global sustainable goal like that. Thank you.
I try to answer the questions, as you expect, me to answer it. What I can understand from your questions, number one, we are talking about legal frameworks in the context of renewable energy, right? As well as, of course, innovations, greenhouse, technology system, all these things. So far, what I can see that this renewable energy is under what we call concurrent list, meaning to say that there are powers that vested to the federal government or central government. There are powers given to the state's government, and then there are powers given to both federal and state government. So then the energy part is actually under the concurrent list, whereas federal and state can share the autonomous power to do the law. But the problem then, the smart thing that happened to Sarawak is that they are looking into all the defined provision interpretations in the concurrent list, and try to make sure that the one that they come out, the law that they come out, is something is not being listed even in the federal list as well as in the concurrent list. It should be falls directly 100% under the state list. See, which is of course difficult. Of course difficult, because it is obviously federal must have power, the state also must have power, but they don't want to do that. They do want to have absolute power, autonomous power, to ensure that they're able to control 100%. So what they are doing is to do or try to define something that not fall under that definition. For example, hydrogen. Hydrogen is a new renewable energy that can move the cars, everything. Hydrogen. Hydrogen, you know that if water, for example, is fall under the federal, because water developments, commercial thing is fall under the federal law, under the federal legislation. But hydrogen is something that not being held by anybody, not even by the state. But they can do something with regard to that, what we call uncertainties of law, or what we call efficiency of the law. By defining their own what we call scope, what is hydrogen? Of course, it's not being held in any interpretative legislative list. Then they come up with the law. This is very innovative in nature in terms of manipulating the legal efficiency of the law. See, that's the smart thing held by the lawyers as well as the law practitioners in Sarawak. This is one example. And of course, in the future, when we try to define more examples of renewable energies, there are probably something that new thing that being discovered by them. But most importantly, it's not the subject matters, it's not the substance itself, but how law give power, of course, autonomous power to Sarawak government to regulate, to govern, to control that things. Just for example, just now, when we talk about transport, transport is not concurrent list. It is absolutely under federal law, meaning to say even state do not have power. State does not have power to control their own transport. You just imagine what happened if you want to do roads, for example, in Batu, in Malang. You must to refer to the government in Jakarta just to get budget. Not only get budget, just imagine, even the maintenance, the development, the structuring of the road must be handled by the central government, despite the location here in Batu, Malang. How difficult the communication is. So you just imagine, if you can see the logistic, the demographic just now, Sarawak is in the northeast of Malaysia. It's not connected directly, see? The other two countries, it is two countries by nature, by Malaysian Agreement 63. Then the development of transport happened in Sarawak. The budget, the control, the management, everything by the federal. Can you imagine how difficult? Just to ensure the completion of the road. It's very difficult. But can you have absolute power to construct your own road? Cannot, because the power is vested to the federal. How then going to take up that autonomous power and give that power back to Sarawak? Of course, you don't have any avenues unless you negotiate. Because according to Malaysian Agreement 63, there's term where these two countries of the agreements, parties of the agreements, can negotiate to give or not to give. Of course, okay, the power given to the federal, but the federal still able to delegate the power back to the state. That's what we call harmonized negotiations. That's the way how these people try to fight for the autonomous power. So not only transport, many other things. All the several enablers that I mentioned just now needs law that should be defined further just to get back that autonomous power. Difficult? Yes, it is a challenges one. It's very a challenges one. Because as I said just now, many of these enablers provision or economic sectors is controlled by the federal, by the central. They want to ensure that okay, they control everything, they can collect everything. But for Sarawak, using all these challenges, COVID-19 as the challenges, they change it as opportunity. This is the time for them, okay, if they want to change the law, try to manipulate the law, try to get back okay, the powers, then this is the time. That's according to their strategy. I think, okay, I hope that okay, I'm able to answer your question. I know, okay, instead of one, two, no, I'll give you extra example for that reasons. Thank you very much for the questions. Right, thank you.
Thank you, Prof. So that's actually the end also for the second plenary sessions. Bapak Ibu, I want you to give a big round of applause back again for all the speakers today. And okay, I'm going to give it back to the MC after this, but we need still some door press also, yeah, to give the door press also certifications after this. Okay, thank you.
Okay, thank you, Ms. Arum. Please give a round of applause one more time, ladies and gentlemen. And please remain on stage because we also have certificate for all of the speakers. So we would like to invite Mr. Bayu as the Vice Dean of Law Faculty to come to the stage and give the certificate to Mr. Foke, Mr. Naji, Mr. Jadi, and also Ms. Arum as the moderator. And of course, after this, we also would like to invite all of the delegates who already asked the question to come to the stage. So please be prepared to all the delegates. Okay, the first certificate will be handed over to Mr. Foke. Let's give a big round of applause, ladies and gentlemen. And the next certificate is for Mr. Naji. The next is for Professor Jadi Zaidi Hasim. Okay, thank you very much. Please take a picture together first. Ya, silakan Bapak dan Ibu bisa melihat ke arah kamera. Well, thank you very much Pak Bayu. Please remain on stage. Mohon berkenan untuk tetap berada di atas panggung. We invite all the delegates who already asked the question to we would like to give the book as the grand prize to all of you. So to 5 delegates who already asked the question, Bapak dan Ibu yang tadi sudah bertanya, silakan Bapak dan Ibu yang tadi sudah bertanya, boleh kami persilahkan untuk naik ke atas panggung dan menerima buku sebagai grand prize di 5th Inklar kali ini. Okay, so the book will be given by Pak Naji. Pak Naji, kami persilahkan untuk dapat menyerahkan buku sebagai grand prize. Bentuk apresiasi kepada para penanya yang sudah berpartisipasi aktif hari ini. Baik, sesaat lagi mohon berkenan untuk bersiap Bapak dan Ibu sekalian. Seluruh peserta kami mohon untuk dapat bersiap untuk berdiri dan kita akan berfoto bersama di depan stage. Jadi Bapak dan Ibu bisa bersiap untuk berdiri sesaat lagi. Kita akan berfoto bersama di depan stage bersama dengan seluruh narasumber kita, speaker kita di siang hari ini. Please remain on the stage. Oke, Bapak Ibu kami persilahkan untuk dapat berdiri dan berkumpul bersama. Kita akan berfoto di depan stage bersama dengan seluruh peserta. Bisa naik ke atas stage, boleh juga di depan stage. Kami mohon berkenan Bapak dan Ibu. Kami persilahkan. We invite all of the delegates to come to the stage or in front of the stage. We would like to take a picture together with the speakers and also all of the delegates of the 5th Inklar. Sekali lagi kami persilahkan Bapak dan Ibu sekalian, kami mohon berkenan untuk menuju ke depan panggung ya. Kita akan berfoto bersama. Tanpa mengurangi rasa hormat, kami mohon berkenan untuk mempercepat langkahnya sedikit karena kita akan segera bergeser menuju ke agenda berikutnya. Boleh di atas panggung juga Bapak Ibu sekalian. Baik, silakan boleh di atas panggung, boleh juga berada di bawah. Oke, silakan dipastikan bisa terlihat semuanya Bapak dan Ibu. ke arah kamera. 3, 2, 1. Sekali lagi. 3, 2, 1. Cukup? Cukup baik, terima kasih Bapak dan Ibu sekalian. Thank you very much. Oh, belum. Please remain on the stage, Bapak Ibu. Please remain on your position. Kita akan ulang untuk kamera berikutnya. Okay, just give your biggest smile. 3, 2, 1. Okay, could you please make a sign like love? Love sign. Love. Okay. Okay, please make a sign like love. Make a love. Yes, and say together, we love UMN. Okay, one more. 3, 2, 1. We love UMM. Thank you very much. Terima kasih banyak Bapak dan Ibu sekalian. Sesaat lagi kita akan segera bergeser menuju ke main campus of UMM. So Bapak dan Ibu, we have shuttle to bring you there. Jadi jangan khawatir Bapak dan Ibu, silahkan prepare. Sesaat lagi kita akan go to the next session, which is the parallel session at the 8th floor of GKB4 at UMM main campus for the parallel session. So good luck for the presentation and wassalamualaikum warahmatullahi wabarakatuh.